after the attorneys have placed their appearances on the record. So once the case is called, the attorneys will place their appearance on the record, then unmute your device, turn on your screen, and state your name. The court will call the case of Ypsilanti Township versus Zachary Bursky, case number 25T00069.
Paul Barnett on behalf of the township.
Your Honor, good morning. Joe Simon on behalf of Mr. Bursky. Mr. Bursky, unmute your device and state your name, please.
Zachary Bursky, Your Honor.
All right. Mr. Bursky was arraigned in front of the magistrate on May 14th, and the bench warrant was recalled. I do have an ROI in the form in the file. Is Mr. Bursky in Don Farm?
Yes, Your Honor. So he has been in the residential program. That's where he's logging in right now. He remains in good standing. I do have an update letter that I can read some of the bullets to the court if you'd like.
Yes, please.
It says, since May 1st, 2025, Mr. Bursky has been a resident at Don Farm. He is progressing well in treatment, consistently fulfilling his objectives and maintaining sobriety. Currently, he is working on the following goals. A, reducing cigarette use, limited himself to 1 cigarette per smoke break. 2, he's he's completing his history of addiction paper by actually, I think he would have completed that by the time of today. Spending 5 to 10 minutes alone each morning in quiet prayer or reflection, and he is journaling. Is focusing on God's presence, graces, insights, and gratitudes. He is focusing on his own recovery rather than others. As part of this, he is writing 1-page reflection. He is exercising at least 5 times per week, and he is improving his personal organization, including ride-out numbers, his mailbox, room cleanliness, and paperwork. Pardon me. It concludes that Mr. Bursky continues to show motivation and engagement in the recovery process. And he has signed a release so that the court can make verification as well.
Thank you. All right. Where are we with respect to the bond violation? I'm going to just not proceed on that today since he is in Don Farm, if that is okay with you, Mr. Barnett?
It is. I'm glad to hear he's making progress.
Me too. Thank you. All right, where are we with respect to the pretrial?
Your Honor, I haven't really even approached Mr. Barnett on this because the blood alcohol level was so high and then my client had the violations. What I suggest, if the court and Mr. Barnett will agree, is let's get him much further in Don Farm or even complete before addressing the pretrial, if the court would consider a rather lengthy adjournment for that.
I'm fine with that process. I'm sorry.
How long of an adjournment are we talking about?
Mr. Bursky, if we go out 1 month, you should be completed with the current phase you are in. Is that correct, sir?
I am currently actually today looking to phase 2. If I do not get that, I would be applying again for next week. For phase 3, which is when you get your leave date after you go to phase 3, that is 3 weeks after you get accepted into phase 3. I am currently at 47 days in Don Farm. Normally it takes around, on average, 90 days, but there are people that haven't completed the program for closer to 110 days, 120 days. So I'm not certain on the exact date that I would be completing, but it would be at the earliest around August, late July, at the latest mid-August, Your Honor.
Thank you. Mr. Simon, are you available on July 22nd, just so I can do a catch up to see where we are with his treatment?
It's a difficult day, but I will be in town. If that, I'll make it work, Your Honor. Yes, I'm in pretty much the 14A3 district court all morning, but I'll make it work.
July 22nd, 2025 at 9:00 a.m. Bond will continue. Pre-trials adjourned to then.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you as well.
You as well, Your Honor.
Thank you. State of Michigan versus Bradley Germain, case number 25S00117.
Tiffany Woods for the people.
And good morning, Your Honor. Dan Garrett on behalf of Mr. Germain. Brad, can you state your name, please?
Bradley Germain.
Thank you. We're here for an adjourned pretrial in this matter.
We are indeed, Your Honor. I believe we have a resolution. I'll allow Ms. Woods to place that on the record.
Judge, he can plead to an added count of OWVI.
All right, so it's my understanding that you're going to be pleading guilty to an added count of operating while visibly impaired. That is a misdemeanor. It carries a maximum penalty of up to 93 days and or a $300 fine plus court costs. In exchange for that plea, the much more serious offense would be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
All right, thank you. If you would rate, and that's what you want to do, correct?
Yes, Your Honor.
Please raise your right hand and be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. I'm gonna go over some rights that you have that you're gonna be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again. You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
You understand you're going to be giving up each and every one of those rights and you're not going to be having a trial of any sort.
Yes, Your Honor.
Do you also understand that there's no automatic right to appeal this decision? So the decision you're making today, in all likelihood, is going to stick with you.
Yes, Your Honor.
And if you were on probation, parole, or bond when this happened on February 2nd of 2025, and you could be in violation of that probation, parole, or bond. Were you on any on February 2nd?
No, Your Honor.
And if you're not a US citizen, you could have immigration consequences. You understand that?
Yes, Your Honor.
All right, to the charge of operating while visibly impaired, how do you plead?
Guilty.
Anyone promise you anything other than what we put on the record to get you to plead guilty?
No.
Anyone threaten you in any way, shape, or form?
No, Your Honor.
All right, thank you. Let's turn to the date of offense. On February 2nd, 2025, were you operating a motor vehicle at the vicinity of I-94 and Huron Street here in Ypsilanti Township?
Yes, Your Honor.
And while you were operating that motor vehicle, were you under the influence of alcohol?
Yes, Your Honor.
All right, it's my understanding that the BAC was a .172. Is that, do the parties stipulate to that?
Yes, Your Honor.
Yes, Judge.
So stipulated, Your Honor.
Thank you. I find that there's a factual basis for the plea that's been willingly and knowingly made. Are you satisfied, Ms. Woods?
Yes, Judge.
Mr. Guerin?
Aye, Your Honor. Thank you.
All right, thank you. Sentencing in this case will be on July 22nd.
And Your Honor, he did get an evaluation completed with Mr. Statton, and just for the record,
Oh, it's already been done.
it's already been done.
How about July 8th? Would that work out with your calendar?
That would be just fine, Your Honor.
Yeah, it might not be enough time. Well, they already have.
Either one's fine, Your Honor.
All right, let's stick with the July 22nd.
Sure.
All right, and that'll be at 10 o'clock a.m. So, sir, you still need to contact the probation department, Mr. Guerin. I'm sure we'll give you the telephone number.
Will do, Your Honor. Thank you so much.
Count one is dismissed, and you're all set, sir. Have a good day.
Have a good day, Your Honor.
Thank you, Your Honor.
Thank you. The court will call the matters of Dylan Turner, case numbers 24S0422, as well as Ypsilanti Township 24W000996.
Do you have any words for the people?
Paul Barnett on behalf of the township.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Turner. Mr. Turner, could you please state your name for the court?
Yes, Dylan Turner.
Thank you. Good morning, Mr. Turner.
Good morning, Your Honor.
All right,
And
we're
your-
here for pre-trial is on both of these matters.
We have a resolution to move forward with today, Your Honor. Ask the prosecutors to put on the record, please.
Yes, Judge, the plea offer in this case would be an OWI.
And with respect to the township case, if he successfully enters that plea, I'll dismiss the township case.
All right, so it's my understanding that you're gonna be pleading guilty to an added count 2 of operating while intoxicated in case number 24S00422. Upon a successful plea to that count in case 0422, then the second ticket with the Ypsilanti Township for PBT refusal would be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
And that's what you want to do, sir?
Yes, Your Honor.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I did.
Thank you. You may lower your hand. I'm going to go over some rights that you have, sir, that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again. Okay.
Okay.
All right. You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
You understand you're going to be giving up each and every one of them, and you're not going to be having a trial of any sort.
Yes, Your Honor.
You also
My only
understand that there's no automatic right to appeal this decision, so in all likelihood, the decision is going to stick with you.
Yes, Your Honor.
And if you were on probation, parole, or bond on March 30th of 2024, when this happened and you're still on it, you could be in violation of it. Were you on any of those on March 30th?
No, Your Honor.
And if you're not a US citizen, you could have immigration consequences. Do you understand that part?
You
Yes,
two
Your Honor.
wanna, whoever's here from Bates or wherever else, you guys wanna talk? See if come on up to the podium, Mr. Hicks. You're limping. You wanna have a seat at the table?
I'm sorry, Your Honor.
I said you were limping on your way up. If you,
I'm just old. I think I didn't arthritis.
no, I understand. I'm just asking, you wanna have a seat at the table?
No, I'm good. Thank you.
You sure? All right, tell me your name, sir,
Jerry Hicks, Your Honor.
and your name, ma'am.
Good morning, Your Honor. Diane Warren from Michael H. Chevrolet, General Manager and Community Agent.
All right, I think you said Warren is your last name, correct?
Boring, B-O-R-I-N-G.
B-O-R-I-N-G.
I've heard of a joke.
Diane Boring.
Correct.
All right. And your two names,
Sherry Graff?
G-R-A-F-F,
Yes, sir.
S-H-E-R-R-Y.
Yes, sir.
Ma'am, your name?
Megan Morris?
M-E-G-A-N?
M-E-A-G-A-N.
M-E-A-G-A-N, Morris, M-O-R-R-I-S.
Correct.
All right, today is the date scheduled on a small claims matter. Before we go on, I need to advise you of your rights. You don't have to proceed in the small claims division. Mr. Hicks is sued for $4,000. You don't have to proceed in the small claims division, though, if you don't want to, defendant. So in other words, if you proceed in the small claims division, both of you are giving up certain rights. The company is giving up certain rights, as are you, Mr. Hicks. You're giving up the right, sir, to seek in excess of $7,000. You're giving up your right to have a jury trial in this case. You're giving up the right to hire a lawyer to represent you in this case. And you're giving up the right to appeal my decision in this case. That is the same for Bates. Do you understand those rights, Mr. Hicks?
I certainly do, Your Honor.
Do you understand those rights, Ms. Boring?
Yes, I do, Your Honor.
Do you wish to give up those rights, Mr. Hicks?
I do not, sir.
You want to have the case removed?
I do not, I'm sorry. I want to proceed with the case.
So you waive the rights that I just enunciated?
Yes.
Are you sure? Yes?
Yes.
I just want to know, she has to take down what you're saying.
Okay,
Do you waive those rights?
yes.
Ms. Boring, on behalf of Bates, do you waive those rights?
Yes, I do, Your Honor.
Are these two going to be witnesses?
Yes,
I'd like you two to go right over there to the jury box. One of you can step in the jury box. That door pulls out and the other one can stand. Pull that door out there, please. And then one of you can go in there and the other one can stand outside. That is a microphone. So I want you to stand right by that microphone, Ms. Graff and Ms. Morris. I'm going to ask all of you to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Mr. Hicks,
I do,
Ms.
Your
Boring,
I do, Your
Ms.
Honor.
Graff,
Yes, I do.
Ms. Morris.
I do.
I don't know what this means. Says defendant failed to repair the 2003 GMC Yukon. You listed the VIN number. Defendant also refused to release that vehicle to the plaintiff.
That's
Oh,
correct.
did you pay them $4,000
I did, Your Honor. I have a receipt that I did pay the $4,000
to perform what type of work?
to repair my vehicle.
Yeah, I know, but
Well, I didn't know exactly what was wrong with it. I took it to Bates Chevrolet on the 16th of December and dropped it off. And on the January the 7th, Megan called me and told me that the vehicle had serious internal problems and it would be cheaper or it would be like they could order a new refurbished engine and it would probably cost about the same as for them to go inside and try to figure out what was wrong with it.
okay. What did you tell them to do? That was January 7th of 25. Yes?
Yes, sir, Your Honor.
You took it in December 16th of 24, correct?
That's correct, Your Honor. On the, if the court allowed me, on the 15th, Megan advised me.
Megan? Ms. Morris?
Morris.
Okay.
She called and advised me that my vehicle would be ready in a couple of days. So I paid $4,000 for that receipt.
What did they do to the vehicle?
Pardon?
What kind of work did they perform?
They were supposed to rebuild the engine, put in a refurbished engine, put my engine back together.
Okay. Do you agree with everything you said? Did they agree to put in a refurbished engine for the price of $4,000?
No, sir, the cost of the refurbished engine was $8,000. So we got a name drop, the vehicle was dropped off. We're not able to diag it until the 16th of January. Once the vehicle was diagged, Megan did speak to the customer and explained that there's multiple problems with the vehicle and that we could try a refurbished engine. This vehicle has 251,186 miles on it, sir, and it is a 2003.
How many miles? 200 and...
251,186.
So she told him, is that right? Did you tell Mr. Hicks that you could try a refurbished engine?
So on the day that I had called, first and foremost, I talked to his son. It's his son's vehicle. I talked to his son. I explained that we had to start here, that there could be, at the end of doing the internal issue that it had, there could be more wrong with the vehicle. Total was a little over $8,000. Through Michael Bates, you take down anything over $2,000, you have to have half down to order these parts, correct? So I did that. We take down a date of birth to authorize that because the customer obviously was not there at the time of the call over the phone. Then they put down the $4,000. We went ahead and did the internal work on the vehicle, and there was still issues that I had told them could very well possibly happen, and therefore it did.
And therefore what?
There it did. There was still more issues found after putting in the engine. There was not a couple of days. It takes almost 2 to 3 weeks just to get an engine. So,
All right, so the refurbished engine was never put in, right?
We did put it in because we completed that work
I'm sorry, when did you complete that work?
January 9th, Your Honor.
And the car's been sitting there since January 9th?
Yes, Your Honor, because there were more issues with the vehicle, which we had told Mr. Hicks. So we were gonna do further diagnosis after the engine repair. By the time my technician pulled it in to do the other diagnosis on the vehicle, Mr. Hicks had canceled his payment. So we would no longer work on the vehicle.
So you didn't receive anything then from
So
Mr.
he canceled, he physically came into the dealership, did a $4,000 credit card transaction.
And then canceled it?
And then canceled it out from under us.
So
Yes.
you paid nothing?
No, sir, Your Honor, I have a receipt here. They still have my $40,000. I put in a dispute against Base Chevrolet for the $4,000. And Base Chevrolet responded back to my banker that I got what I paid for. They still have my $4,000.
We did dispute it, we did win, sir. So we do have $4,000 in-house after the back and forth.
How much does he owe you?
He owes us $4,000 right now. The vehicle still has upper engine issues, not the engine itself. But again, Your Honor, you're talking a $251,000 oath.
Well, I know, but
Yeah.
you want to pay another $4,000 and it's still not going to be drivable?
It's not 100%. It is not 100%, but that was.
How much was
not
that
guaranteed.
vehicle worth?
I don't have a value.
Do you have any idea how much that vehicle was worth with 251,000?
I paid, I'm sorry, I don't mean to cut you off. Go ahead, sir.
No, I just wondered if you have any idea what that vehicle
I
was.
paid $3,000 for it a few months later in Arkansas.
A few months later, when? I don't know what you mean by that. In 2003 or just now?
No, I bought the car in '24.
Okay, so a few months before this, you paid $3,000 in Arkansas.
Yes. And I have notes here, Your Honor.
Where'd you get this from, a private seller?
I have notes here, Your Honor, that every time I talk to someone from Base Chevrolet or I went there and visit, I made notes. This is what I'm testifying from today.
I want to hear from you. I want to hear from you.
Well, when she mentions they, there is no they. I'm the owner of that vehicle. So if somebody else has something to say about what to do with that vehicle, that's not my business. I'm the owner.
Okay.
Okay. My major Kim, Your Honor, on the 3rd of March, I called and left a message for the Chevrolet here to call me to discuss the matter. Well, she never called me back. I did hire an attorney, Blake Speck, out of,
I don't want to know your conversations with your lawyer.
okay.
Okay, if he did something for you you think is relevant, feel free, but
I do, Your Honor. He wrote a letter. He also called, talked to Sherry and Megan and asked for paperwork in regards to this vehicle, that's what they've done. Neither one of them responded to him at all.
all right, but we need
I
to,
have an attorney today.
no, I get it.
But when she called me and told me they had an electrical problem, I said, we didn't have an electrical problem before. And about that too, Your Honor. I went to pick up a battery there one day. Megan said, he'll have the mechanic driving into the bay while I get the battery out of the back seat. Probably 10 minutes later, the mechanic comes in and I have a date when this happened.
I don't want to hear this.
Okay.
It's okay, I'm gonna come back. But I want to know.
May I speak, Your Honor?
No, I want to ask a question first, and I'm not sure how I want to phrase it, except to say, it sounds to me like you initially promised, and I'm asking you if this is true or false.
Absolutely not, Your Honor.
I didn't even ask you the question.
Okay.
How do you know? You didn't say that once we refurbish the engine, that, or get me a refurbished engine, that this is going to operate adequately?
A vehicle with $251,000 that is not running, sir, we can't guarantee anything. And the vehicle was for his son, and I think he was just trying to get his son back on the road. We don't want to take anybody's money.
I know, but if he paid $3,000,
total cost around was 5,000 for that motor.
Didn't you tell me you paid 3,000? No, I know 4, but didn't you tell me you paid $3,000 for the car in Arkansas in 24?
yes, Your Honor.
That's what I'm referring to.
Sorry, I
Yes.
apologize.
So we're up to, so now he's spending another $8,000 and the car isn't still drivable? It's not ready to go? I mean, that's like, I don't know what that's like. I mean, that seems like really bad business.
They still have my vehicle.
May I speak, Your Honor?
Yeah,
I completely understand your feelings, and
Well, I wanna get-
initially, when I read this, I truly understand how you feel. However, if he's adamant about fixing a car for his son, all we can do is say, this could happen, or this could happen, and ultimately, it's his decision. I would not invest that kind of money in a 251,000 mile car.
did you have the discussions with him or
No,
did
sir.
somebody else? Who had the discussions with him?
Megan,
What did you tell
I did, when I called him and told him what was going on with the vehicle. that
him? And
he-
he'd already paid $4,000 down.
I wouldn't have known what he paid to buy the vehicle, that's not. it's
No,
not-
no, no,
you know
yeah,
what I mean?
wait, no, I'm not talking about what he paid to buy the vehicle. That was a different issue.
Okay,
He'd already given you guys $4,000.
but when I sold the job and told him what it needed, I told him it was $8,000. I have to have half down to order the parts. The
Right.
parts are a little over $4,000.
Right.
This is by any customer that comes into me.
Right, this is on the 16th, you had this phone
I had
conversation.
this conversation with this gentleman on
And
the
what did
phone.
you tell
Well, first I had the conversation with his son. We need to be open and honest. I told the son, because the son is who I initially had the telephone number in communication with. It is his vehicle. Whether it's in his dad's name or not, I don't know that. So I had the conversation, his son got extremely rude with me to the point to where I didn't feel comfortable any longer talking to him on the phone. At that point in time, he hung up on me. Mr. Hicks had now called. That was my line of communication. He apologized that his son was extremely rude to me and called me every name under the sun. And he asked, what is going on with the vehicle? I said, I had told your son that it came in for a check engine light and the vehicle wouldn't go over 10 miles per hour. It had internal engine failure. This is the cost for it. This is what you have to have down. This is where we need to start. Starting as in means we could put this engine in and you very well might have more issues with your vehicle. I do not know. But we need to get it up and running, at least with the engine in it, because that's what's showing that we have to do first. This gentleman had told me, absolutely, here's my birthday to authorize this job, which everybody has to give a birthday if you're not there in person to sign or to give, we take authorization over the phone with the birthday. I have gotten his son's birthday and his birthday. He agreed to the $8,000. Came and gave me $4,000 down. We put the engine in it, test drove it, still has issues. I called him, let him know that, and now here we are.
Jeez.
I didn't
Is
pursue
what she said-
anything or promise anything.
Is what she said just true?
It's not, Your Honor. She has never mentioned $8,000. I think, Sherry, I talked to her one day, and she told me there was no compression in number 1 and number 7 cylinder, and that my engine had a warranty. I said, well, you bought the engine. You get a new engine in here. $8,000, I think Sherry mentioned $8,000, and I said, what are you talking about, $8,000? The price of the motor. What did you come up with 8,000?
Wait a minute, slow down. So you're disputing her testimony that she.
Absolutely, that's
What, you gotta let me finish. You're disputing her testimony that she said it's gonna cost $8,000 and we need half down or 4,000. You're disputing that?
I certainly am, Your Honor.
So what did she tell you when you gave her the 4,000 before you gave her?
I didn't talk to her.
Let me finish, let me finish.
I'm sorry.
What did she tell you, or Sherry, or whoever you want to tell me, what was conveyed to you as to what would happen once you gave the $4,000 payment to them?
Okay, Your
Or did
Honor.
they tell you 5,000 and you got a new engine?
No, Your Honor, at the very beginning, Megan told me that the engine, refurbished engine would cost $5,000. On whatever date I just mentioned, she told me the car would be ready in a couple of days. So I went into the cashier on the credit card, paid $4,000 down, knowing I still owed $1,000 because I had $1,000 in the bank.
Because you had 1,000 what?
That I had $1,000 in the bank. I
Okay.
paid them for it, total price was $5,000. But after I made.
Tell them it was 5?
No, I told him I need half done what the total was. The total was a little over $8,000. He came in and paid half of it, which was $4,000 even. I don't know where any of these extra numbers are coming from.
Go
Not
ahead.
a clue.
Your Honor, anybody with common sense knows that a refurbished engine does not cost $8,000.
Well,
Everybody knows that.
well, I gotta tell you, I'm not savvy with vehicles. You can say that. I don't know that I would know what a refurbished
I am,
engine
Your Honor.
costs.
I used to own a junkyard too, by the way.
Well, you know dealerships charge more anyways,
I
right?
know. They don't charge $4,000 more than what the motor's worth. She gave me a price of $5,000. I never heard $8,000 till I went in and seen Sherry about where my vehicle was. She said, well, we're afraid you're gonna steal the vehicle. So we
Steal the
moved.
vehicle?
Yeah, they thought I was gonna steal the vehicle.
How are you gonna steal, how would he steal the vehicle?
No, Your Honor, what I said is, he had disputed the charge at that time to 4,000, and we had put in a dispute for that, and he wanted to pick up his vehicle, and I couldn't release the vehicle without payment. Grace put $8,000 into the vehicle,
Right.
so,
That's
We
not
did it.
true, Your Honor.
and if I may, can I speak?
Sure.
Not only did we do an engine, we did, oil cooler lines, we did other repairs as well. I don't have the paperwork in front of me, but we did other things that led up to the $8,000 that he
The
approved.
equivalent though, I wanna tell you, paying $10,000 for a car and then going out and paying about $25,000, $26,000 in repairs to get the car working, it just doesn't make any sense to me that somebody would buy a car for $3,000 that I can't believe would Blue Book for $11,000. And now he's got himself in a position, or at least a situation's created, where he's got to pay $8,000 more and it still doesn't have a drivable car. That's what you're telling me, right? There's other issues to deal with?
He does have other issues, Your Honor, but he also had it at 2 other repair shops before it was at ours.
Is that true?
Sorry, Your Honor.
Did you have the vehicle at 2 other repair shops before? Let me finish.
Sorry.
You gotta stop doing that. See, I don't wanna sound rude either, but she's gotta take down what is being said here, okay? Everything's being recorded.
Yes, Your Honor.
Did you take the vehicle to 2 other repair shops before you took it to Bates?
I took it to Auto Dock, down the street. That was not the problem. I took that there.
What do you mean? What do you mean?
I was having other little issues, electrical issues, the radio. And anyway, I took it to George's, which is on the other side of West Road. I left it there for a week in this parking lot. He never touched it. So I was able to drive it down to Bates Chevrolet and left it in their parking lot and talked to the mechanic or the associate in there. He said it'd be about a week before we get to it.
When the mechanics performed this work, did anybody go out and attempt to drive it?
After the repair was made.
Yeah.
Yes, sir.
And they still said what kind of problems
And that's
exist?
when he had a 3-cylinder misfires on top of the engine. Yes.
Well, this is a mess. So he's giving you 4, you want 4 more, and he still doesn't have a car that's operable, and he paid $3,000 in 24 for a car with 251,000 miles.
And it was his decision to put that money into that vehicle, sir.
Well, but you're the experts, aren't you?
Well,
I mean, that's a little like saying to your doctor, hey, I want you to do this, and the doctor knows it's, or lawyer, whatever it is. You guys are the experts. Couldn't you tell by running all these diagnostics as Ms. Boring was talking about as to what exactly was wrong with the vehicle? So you could say, this is the problem, this is the problem, and that's the problem, and that's gonna cost X amount of dollars. It seems pretty simple to me. Maybe I'm making it too simplistic, but doesn't it seem like that's the way it should have gone about?
It's really not that simple, Your Honor. So we did have to get the vehicle running with an engine. It had 251,000 miles. We did advise him that there may be other issues. He had electrical issues, he had it for down the road, he still has electrical issues. I mean, there's a lot of problems with the vehicle, but he did authorize to repair it for the engine.
Mr. Hicks?
Your Honor. Megan told me that my vehicle will be ready in a few days. All it had to be, is her words, just buttoned up. That was her words.
All that way?
That all it needed to be was buttoned up. That's what her words were.
Do you have any estimates, written estimates for him? Did you give him any written estimates? I'd like to see those.
Yeah, I would too.
Did anybody say on there, hey, no guarantees, might need further work? I want to see the documentation. I mean, you guys are the experts here. It seems to me that on estimates, you would have noted there still may be further issues to deal with, even if we put in a refurbished vehicle. That's the way I'd see it right now. Let me see what you got. Do you have any notations like that on any of this paperwork?
All I have here, I do have a written estimate on here. Well, it's the total for the estimate. You'll see a couple on here.
Tell me what the total for the estimate was. Read it to me. Just you can read it right there. Read it.
8,500 for the engine, intake manifold, exhaust bolts, the gaskets, the engine mounts, the coolant hoses. And then we also did a power steering pump, engine and bolts, necessary bolts and fluids.
Did anybody say there still may be other work that needs to be done?
When Megan spoke to him on the phone, this is our starting point. We always say that because especially when we don't have a car that
You should
is.
put it in writing. Did you say that to him?
I did, 100% I did. I said, sir, this is where we are right now with it. We have to start. My keyword is start with an engine. There very well could be more issues with the vehicle, but we have to start here. Here's the total. This is what I need down, and I need your authorization to do so. Well, how do I get that? Your birthday. I have his birthday. I'm here written, circled, and I even have the total.
Was all that work performed
Yes.
that you just wrote,
Yes,
that you
sir.
just read to me?
Yes.
And you say they didn't tell you that?
No, sir, Your Honor, they did not. And I always say, you know, it's easy to remember the truth, but it's hard to remember a lie. So, you know, somebody's not telling the truth in here, and it's not me. I mean, I'm telling the truth.
Did it have on the estimate, you said 8,500, right?
Yes, sir, it is.
Was that before or after he made the payment?
That was before.
And did you ever give him any kind of receipt indicating that the balance was going to be 4,500 after he paid the 4,000?
No, I do have the receipt for the $4,000 down and his date of birth. Again, that's what we do when we get authorization. If the person is not in front of me, we get a date of birth.
That's it, Your Honor.
Yeah.
All this other stuff that's adding on here, this is the first I've heard of that. Power steering.
Well, but you did get an estimate for $8,500, right?
No, Your Honor, the price was 5,000 for a
Did
refund.
he sign that estimate?
I do not have a signature, Your Honor.
When was that? What is that dated?
This is dated 3/20, oh, I'm sorry, that's his birthday. The only date I have on here is 12/16. That's the day we wrote up the vehicle.
We have the date of when he put the $4,000 down.
Wait a minute. You didn't know? 12/16, you said?
That's when I dropped it off.
That's when he dropped it.
I know, but I thought you didn't know until after the beginning and you called him on the 15th or 16th of January. Didn't we already cover that?
So 1/17 is the date I have.
Let
That's
me
what
see
he,
the document. Let me see the document. I'm sorry this is taking so long, everybody.
Well, Your Honor, I just want the truth to be told here, and it's not been told.
So what do you think you bargained for? See that, please?
I'm sorry, Your Honor.
What do you think you bargained for? An operable car after you gave him 4,000 and you owed him one more?
Your Honor, being a bank Chevrolet, I thought was a reputable dealer, I assume they still are. But when I took my vehicle in there and was told that it needed a refurbished engine, or they could go into the motor and take it all apart, and Megan said it'd be just as well, go ahead and buy a refurbished engine for $5,000 $5,000. I said,
Megan told you that.
yes, sir, Your Honor, I swear she told me. So I said, well, go ahead. I'll have a new engine in my car. Then I get the call, it's gonna be buttoned up.
There's just scratches and notes here.
With all this other stuff. Yes, I did sign for.
Labor 3,800, it looks like you're saying estimate, right? 8,500 by Jerry Hicks, date of birth, and you have his date of birth on here.
I also have his son's date of birth, because that's when I started talking to him, before it went south with him.
I did sign, Your Honor, to have the $5,000 motor put in. This other stuff, I have no idea what.
You signed what?
I'm sorry, Your Honor.
What'd you just say?
I did sign a paper. She had me sign a paper for the refurbished engine at $5,000.
Let me see it. Do you have a piece of paper that shows me that?
No, she has the paper.
Do you have that paper?
It's what's in front of you, Your Honor. He didn't sign it. He gave us his date of birth.
Well, maybe it may have been a sign.
Slow down, everybody, please. What is it? I mean, these are scratchy notes, my lord. What am I supposed to know here? I mean, you got $5,500 written in circles here. What does that mean?
So
Just those.
the $5,500 was just for the reman engine, and then he added on the power steering pump, the lower trans lines, the left engine mount, and necessary bolts and gaskets. And I do remember you authorizing that because you had argued with me that nobody, or you didn't argue, you just told me that no one else had found the leaks at the other place. And I said,
Do you think he owes you money now? You didn't counterclaim. You guys didn't file a counterclaim. So this car's just been sitting in the shop for all this time? What a mess.
Can I speak, Your Honor?
Yeah.
I have no idea where my car is. It's not in the shop. I don't know where my vehicle is at. Someone mentioned, I don't know who mentioned it, but one of these, I don't think it was this young lady here, somebody mentioned that they could get a quick claim deed of a mechanic's lien on my car and take it.
Is the car still at the shop?
yes, Your Honor, and we have
If I went over there right now, I will see the car at the shop.
So we have a building next
True or
door to us.
false?
Yes, true,
Okay.
true.
I know how this should resolve. I'm just trying to think of how I'm gonna do it. Well, if you don't mind me saying, as an advice to you guys, somebody needs to keep better paperwork here. This looks like scratch notes that I would have used in third grade. I mean, I can't even read this. And you got numbers all over here, like $5,500 it says, and it looks like it says doing this. What does that mean? Who wrote that? 5,500.
Mine.
And somebody else wrote 114,000 miles, it looks like, right? Do you have an extra copy of this?
I'm reading it with you, yes.
What does that mean? 114,000. What does that mean? Miles, it says next to
Oh,
it.
that's probably what the reman engine came with on it.
That's what those miles are. The word actually says miles. That's what
Okay. What's it say? $5,500. What's that?
That's just for the aftermarket. That's just for the price of the motor. That's how much the motor cost alone. That's why I'm really confused when it's just the fourth. How is that when the part alone was over 5,000?
I had something, Your Honor.
Yeah.
Megan did tell me that there would be tax on the $5,000.
That's 300, right?
I don't know, I don't know what it was. But she said it was $5,000, and then later on, we was talking about it, because I mean, they're nice people, you know. And she
Oh, I
said,
get
"My
it.
rate is gonna be taxed on that $5,000. That's about it.
Where does it say anything on any of these estimates? I'm gonna ask you to look at this and tell me where it says anything about $8,000.
Right up here, it says 8,500 okayed by Jerry Hicks, date of birth.
Yeah, but I didn't say,
4/1/47.
nobody told me anything about 8,500. She told me he owed another 4,000.
Mhm.
There's a difference. He gave him 4, I can do math, 4,000 and 4,000 is 8. Why did somebody write 8,500 on here?
Because I did tell him that it was $8,000 plus the tax.
Well,
So
that,
I mean,
what,
we always round up just in case of, there's additional parts at the end, always happens. But that circle that is right there with his date of birth, everything on that is exactly what was authorized.
well, you have his date of birth on there,
And I
right?
have his sons also.
I know, I see that.
That's it, Your Honor.
Yeah,
My son has nothing to do with this. He's my son. As far as authorizing this or authorizing that,
what do you intend, let me stop you a second. What do you intend to do with this car? You're gonna just assert a mechanics lien? Is that what you guys are gonna do? And
Your Honor, our business reputation is worth more than anything. I do believe there's confusion because if the cost of the motor is over 5,000, we have to pay our technicians.
Well, I
They're
get it.
to feed their families, there's labor involved. And I don't know if he's forgetting or what. I was not.
I find him to be believable, and I think he's got enough common sense, and I believe he's got enough common sense to recognize that you don't buy a car for 3,000, put 8,000 more into it on the IFCOM, that it will drive appropriately, and if it won't, that it's gonna cost me more money. That makes absolutely no sense to me. So I can tell you, I think,
Your Honor, may I speak?
yeah,
Please don't forget that he did take it to 2 other shops. And
He-
he was frustrated
he
with the other 2 shops.
well, the first one he took it to was something about a radio, and the second place it sat there for a week, I thought he said, at George's, and they didn't do any work on it, and he wanted to get the car running. True or false? So I think,
There was part.
wait, I think, in fairness, as strange as this might sound, I know it should happen, I just am trying to figure out a way to do it because you didn't file a counterclaim, okay? And I don't want to spend all day on this, but I want to do the right thing. I think what I'd like you to do is you should file a counterclaim if you think he's got another $4,000. Jennifer, I want you to listen, please. If you think he owes you another $4,000, you should file a counterclaim. And then, I'd like you to bring in the mechanics. I'm shocked that they can't figure out in the beginning how much money it's going to take, at least in a ballpark. I find it incredible to believe, like I said, that he would pay an extra $8,000 or $8,500 on the IFCOM, that this 251,000 mile car is going to operate won't operate without the potential of further work. You can't just say, I'm going to fix this and this is what it is, and then not say, well, we don't know if it, did anybody lead you to believe that this was going to require further work?
no, Your Honor, did not.
Yeah, I don't believe.
I'll just-
Jennifer, I'm going to send them down. And I'm gonna have Bates file a counterclaim. If you think he owes you 4,000 or 4,500, you can file a counterclaim. And then I think we need to hear from the mechanics.
I'll bring the mechanics.
Now, I'm no expert. I hope you're gonna have some good questions for him, okay, Mr. Hicks?
Just may I say one, may I get the possession of my vehicle from Base Chevrolet?
I can't do that yet. I'll move this case for you, though, I promise you. I promise you. I will move this case quick. Jen, when can I do this? Can I do this, if you think you can get the auto mechanic, I could do it next Tuesday or Wednesday.
Perfect.
No,
What?
on the 23rd, you have, yeah, we could do it at the end of your landlord tenants next Monday.
Good.
Would that work?
Sure the mechanic's gonna be available?
I'll make them available.
We'll adjourn this to June the 23rd at,
11:30.
and you go down and prepare a counterclaim.
Got it.
Counterclaim. And then they're gonna serve it on you. I just want you to be aware. They think you owe them $4,000 or $4,500 or $44,000 plus tax, which I guess would be another $480. I want copies of that, and then I want you guys to but John's bringing down some copies, Jen, and I want to make sure those are given to me, okay?
Okay.
Yeah, but we're not gonna resolve it today, so make it
Would
short.
it be possible for you to have Bates Chevrolet bring papers that I signed for work to be done?
Yeah. Well, they're saying they don't have them. They just have this approval order that was done verbally, and that's why she took your date of birth. But yes, any and all documents in any way related to this transaction, you are to bring here if they are not here today. Okay? So bring all the documents related to this transaction. Bring them, the mechanic or mechanics that worked on this. And we'll do it next week at what time, John?
11:30 on the 23rd.
Next month.
My only question, Judge, is service. If we could.
You're gonna accept service, right?
Okay.
Yeah, you just accept service. Wait for them to fill out the counterclaim. Let's not make this any harder than we need to, and we'll go from there, okay?
I thought it was gonna be an easy case, but
Well, I don't think it's as easy as, that's all I can say. Thank you all. Thanks for your patience. Okay, let's go on. I gotta take one of these real quick. I gotta get GTSC Warehouse. Are they here versus Adkins, Christopher Adkins?
Yes, Your Honor.
2404976. Mr. Adkins, your name, sir?
Christopher Atkins.
Ms. Kuzi, are you on this?
Yes, sir. Thanks, Cruz, on behalf of the plaintiff.
All right, good to see a smiling lawyer. All right, did you two talk and resolve this or not?
We did have a chance to speak and we could not come to a resolution as of today.
What's this about?
Yes, Your Honor, we had filed a claim of possession action. The date that we had filed suit was in December of 2024. And we were up to the point where we were able to submit a default request and entry, and defendant did end up filing an answer about May 7th. As of today's date, we did speak, there is no tribal issue of fact. He did indicate that he is going to be trying to file a bankruptcy, Chapter 13 bankruptcy, but we have spoken and he agrees that he owes the amount. There's no tribal issue as to that, and he does not dispute it. Plaintiff would be seeking to enter possession judgment today, as there's no tribal issue. He agrees he owes the amount. It's just, tactic for him to delay this matter. His balance is exceeding about $15,000 as of today. He's indicated that he's going to be trying to file Chapter 13 bankruptcy. We tried to come to a resolution, but we could not, get.
Mr. Adkins, you need to talk to a lawyer, sir.
Oh, yes, Your Honor. I have one. I'm in the middle file. I had a delay in my tax return filings. I just filed them. They just went through. And I also did the financial class for him. And I spoke with him in the middle of our intermission.
I don't need to know what he tell you.
Okay.
Okay.
I don't know what to do.
Hang on just one second.
I don't know the balance. The balance sounds a little high to me, but
Just wait 1 second. Just wait.
Yes, sir.
Let's adjourn the pre-trial. I'm gonna adjourn it for 3 weeks. You can go consult with a bankruptcy lawyer and anybody else you want to. Jennifer, give me a new date, please.
The 15th, Your Honor.
At
8:30.
That is what day of the week? A Tuesday?
Tuesday, yes.
July 15th at 8:30 will be the pretrial. You seek a lawyer, Mr. Adkins, okay? And I'm not gonna take any action on this at this time. And if you guys want to prepare a consent judgment, I just think he needs to get a lawyer on this, okay?
If we could get a motion hearing date, plaintiff would then intend to be filing an MSD. I did speak to him. He confirmed that he is speaking to a bankruptcy attorney, and he confirmed that the attorney is not representing him in this case. So I did confirm with him before I spoke to him, and he confirmed that from the beginning that he wasn't representing him, and then now he keeps going back and forth and saying, oh, he may be representing me. So he's just, playing a tactic to delay this matter, but he did confirm before I spoke to him that he's not being represented by an attorney on this matter.
No, I don't have any doubt that you wouldn't have spoken with him if there was a lawyer representing him. Let me be clear about that. I'm just going to give him 3 weeks to regroup. He's got some equity in that. I don't know what his financial situation is. It's a little more complicated than a regular debt collection case. You have July 15th. Bring your lawyer or you show up, but I'd strongly suggest that you bring a lawyer, okay?
Yes, Your Honor.
That's what we'll do. Okay? Ms. Kuzi, you're looking like you're not satisfied, but you can join the chorus of those who come into a courthouse and leave unsatisfied.
Motion hearing days, since we do intend to file a motion for summary disposition, we could get a date today.
Yeah, you call the civil department. I'm just adjourning the pretrial, and then you call the civil department. They'll give you one. It's probably going to be on Tuesdays, right, Jen, for the most part?
Yeah, yep. I mean, I have July 29th. I could give her right now at 10
So you can
o'clock.
take July 29th if you want, and you can set it any time in the morning, okay?
Okay, thank you, Your Honor.
Have a great day. Thank you both. Midland Credit versus.
So let's see, I've got Mary Hull here in the courtroom. Why don't you have a seat over here at the table? Ms. Warner or Burden, Ms. Burden, you're on Zoom, just have a seat. And that red lighted thing, if you could pull that more in front of you, that's what's picking up your phone, your voice. You don't have to lean into it or anything, just make sure it's in front of you.
How's that?
Yeah. All right, so we're taking up case number 25162. And let me, and both of you should know I'm looking over here to another screen because all of our files are electronic. And so I am listening, but I'm also looking at what's been filed and all this information. So just give me a moment to get everything pulled up so I can pay attention.
May I get my water, Your Honor?
Okay, get your water.
Oh, sorry, pardon me.
Okay, so let me put you both under oath. So I've got you here, Ms. Hull. Raising your right hand, you swear to tell the truth, the whole truth, and nothing but the truth.
I do.
All right. Then turning to you, Ms. Burden, raise your right hand. I think it'd be your other right hand. Is that your left hand? Or are you flipped? Sometimes on Zoom it flips, and you need to unmute. Why don't you unmute?
It's flipped.
Okay. So, Ms. Burden, do you swear or affirm you'll tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, so this is a temporary order that was issued on behalf of Ms. Hull against you. And today is the hearing to determine if that order continues after this hearing or not. And I am looking at this petition. Give me just a moment. I've reviewed 18 different petitions. Let me just re-review so I know what we're talking about today. And then I'm going to take any information either of you want to tell me here. Let's see. All right, so first things first. So Ms. Burden, then you received notice, it looks like June 5th. Looks like you got the temporary restraining order and the petition about this case?
Yes, I did.
Okay, and Ms. Hull, first question is, do you want the court to consider having this order go longer than today? Do you want this order?
Yes, please.
Okay. Ms. Burden, do you have an objection to the court issuing this order?
Yes, I do.
Okay. And then, Ms. Hull, are you prepared today for the hearing?
Yes.
So there isn't anybody else you're going to bring, no other information. This is it.
Right.
Okay. And Ms. Burden, are you prepared for this hearing?
Yes.
To respond?
Yes, I am.
Okay. No other information that you're going to say, gee, this is it. There is no other hearing after today, right?
No.
Okay. All right. Great. I always want to be sure. So your neighbors, and so Ms. Hull, I've reviewed the information you've given me. Now, the information from is Mr. Richard Hull, your husband?
Yes.
Okay. I see that you filed that information. The problem is there's a certain legal standard that I have to follow, and that's not signed under a penalty of perjury. I have to kind of give it some lesser weight. Because of that, but I can certainly hear from you and what you know. Not what others are telling you, but what you know, not hearsay. That's what others are telling you about things. It's what you know. And so the email that we received from someone that you filed as exhibit, also, I have to kind of pull back a little bit from that too, because it's not under penalty of perjury and they're not here for me to cross-examine and judge credibility. So, and Ms. Burton doesn't have a chance to do that either, but I can certainly hear from you, as you've said in your petition, and anything else that's other than your petition you want me to know. And then I'll turn to Ms. Burton on her response. But what would you like to say about the issues that got us here?
Well, on the Sunday that this happened, I had, I'll digress a little bit. I had about 10 minutes prior to this incident, I had broken up a situation where my son had been hit in the face with a basketball by the older kid, one of the kids that her daughter plays with. And I had just dealt with that situation prior. I can come back to that if I need to. The kids were trying to get him to say.
Tell me what actions Ms. Burton took that you think are unlawful harassment.
My son came home sobbing that she had screamed at him. And it had been about a week prior. I'd witnessed his little friend. It happened to his little best friend too.
How old is your son?
He's 9.
Okay.
Did
you hear any of this? See any of this?
The incident prior that I broke up between the kids? Yeah.
Okay.
So I walked
but I mean,
over.
the actions of Ms. Burton. Did you hear her screams? Did you hear her words?
I had just been over there. And I came in and I was cleaning my house and my son came in crying that she'd screamed. And I just walked over there to tell her to quit, that if she needed to yell at somebody, you know, she could yell at me. He's disabled. He's intellectually disabled, cognitively delayed. He's been in
so your son comes in crying.
Yeah.
And it's soon
and I
after
walked
the
over
event.
there and
what did
she
you
answers the door.
Slow down. I have a question. Your son comes in crying. He's all upset. It's soon after it occurred. What did he tell you?
He said that she screamed at him. I think the incident prior might have.
Was he able to tell you what she said?
I don't know what.
Screamed at him.
Yeah.
Okay, go ahead.
And so I went over there and like I said, I think it has some bearing on the incident prior with the children. If I have time, I can go into that, or I can come back to it. But I knocked on her door and she said, "I'll be with you in a minute. I'm talking to the landlord," which I confirmed with my landlord she wasn't. And I said, "I'd like you to talk to me now. If you want to scream at somebody, why don't you scream at me?"
Mm-hmm.
And she said something to me. I said, "What are you talking about?" She goes, "Well, why don't you put a bra on?" At that point, I realized she'd been drinking. Mm-hmm. I tried to interact with her a little more. It didn't go well. It didn't get anywhere. I did tell her she was a crazy drunk B word and I wasn't going to talk to her anymore. I went to walk away because I told her, I said, "You know, my son's developmentally delayed. Gabe's developmentally delayed." She goes, my kids are developmentally delayed. I have developmentally delayed kids." I said, "Okay." I went to walk away. She's yelling at me that my husband's going to lose his job because of me. I went back. I went back to my house. Then I got a water and walked over to a friend of mine's apartment that lives upstairs. And I was sitting on her balcony talking with her. And at that point I saw, when I walked by to go there, she's hollering at me, "Where is your husband, Mary?" I said, "That's none of your business." And I went upstairs to my friend's house and I saw my husband pull in. And within a few minutes, I saw her walking that way with her phone up because her building's here, my building's back here. And he was sitting outside at that point. And I called him and I said, "She's heading your way." He said, "I know." That's when I went back to the apartment. My older son was
Let me
there.
back you up here. So what does your husband do for a living?
He's the maintenance supervisor at the apartment buildings we live at.
Okay. And why? So you hear from Ms. Burton, what about his job?
She kept saying that I was going to cause him to lose his job, implying that in some way she was going to try to make him lose his job.
Okay.
because I tried to come talk to her about not continuing to scream at my son.
So you both live, given the addresses, that's why I was a little puzzled, but you both live in the same complex.
Complex, yeah, not the same building, but the same.
Yeah,
complex.
okay, that's why, yeah, both have apartment 101.
Right.
Okay. And so has anything come of effect to
that
your
point-
husband's job?
No, at that point,
No,
if I may, at that point, because I was back at the apartment by then, she said if she told him that she wanted to talk to him, and he said, "I'm not going to talk to you. You're drinking, you're drunk." And she said, "If you don't talk to me, I'm calling the police." Well, a little bit later, he refused to talk to her, and a little bit later, the sheriff showed up, and the police told me that she called them and said that I had threatened, in their words, that I had threatened to kick her ass, which I had not done.
Okay.
And I asked them, is there any recourse I can take? She's constantly yelling at other kids. She's yelled at my son. I don't have a
Let me
record.
back you up. So you did not say that. The only thing that you're
Right.
admitting to here is you called her a crazy drunk. You said B word. Does that mean bitch?
Yes.
Okay.
And I did tell her she was a piece of shit human as I walked away because of the things she was saying.
Okay.
I'll own that.
Has there been any time in the past that you may have said something along the lines that you heard from the police that you said? Did you ever threaten to kick her ass, ever threaten her
Nope, that's
harm?
why when they told me that, when they looked at me, they asked me, they said, well, she called us and said, you threatened to kick her ass. I said, I've never done that. Do I have any recourse if she's, I said, can I get a harassment order? And the officer said, yes, I would get there first thing in the morning. It's first come, first serve, which said to me that not only was she trying to get me in trouble for threatening her physically, but that she was going to try to get an order against me for something I would never do. I have never been in a fight. I didn't threaten to physically do anything to her.
How long have you both lived in this complex that you're aware of?
We moved in about a year ago. I don't know how long she's been there. I know that
A year. All right.
there have been
And your husband's been working there how long?
over a year. It's
Okay.
been
So he started work and then you moved in there and here we are.
right.
And when did all this kind of bubble up, this conflict? When did it first begin?
It all happened. It all happened that day. I had already been aware personally of her yelling at other kids and heard her more than once screaming at kids. But on this particular day, she screamed at mine.
All right. And you don't know what she said, but you talked to her and then
tried
an ugly comment. All right. Just looking at the things that you filed here, and if I have some questions before I turn to Ms. Burden, just look at things here.
And if I may, Your Honor, there was an incident prior, like I said, that I can refer back to, that I know what happened. And
you were there?
I was in my doorway. My apartment's here. The kids were playing right down kind of off to the side. Her apartment's here. They were kind of over here.
Mm-hmm.
And my son had about 10 minutes before that come in with a fat lip from a different child that had hit him in the face with a basketball, that plays with her daughter. And he had just gotten hit in the face with a basketball. So, but I know that whole thing, and I had gone down and sent that child home. And
how does that relate to your
that's why I didn't. That's why I said if I have to come back to it, I can. I don't know.
So how does that have to do with what unlawful harassment committed by Ms. Burton, that incident?
Right, it doesn't.
Oh, okay.
I'm just
right. I'm not missing something.
I'm just saying that all happened around the same half hour of time.
Yeah, it was a bad day. All right. Gotta look through. Can you give me the packet? Thanks. Just make sure I got everything here. And so this was all, let me get back to it. On June 1st, which was that Sunday. Okay, and all right. Anything else before I turn to Ms. Burton?
No, Your Honor.
Okay. All right, Ms. Burden, you need to unmute. And then what is your response to this allegation that you committed unlawful harassment against Mary Hull?
I'm I've read through the statement. I'm pretty shocked because there's a lot of exaggeration, there's a lot of slander, and there's outright lies.
Tell me what you think. Tell me why you don't believe you committed, you disagree with this petition. Tell me your side of things.
Go through what happened that day. I've been here since April 2022. I've never had any complaint. According to my landlord, I double checked with her. My intention, just before I start the story, my intention was never to have Rich lose his job. I was very specific when I spoke to Liana, our landlord, that he is a great employee. He had nothing to do with it. He wasn't involved there. It was her. So what happened was this story. So I was very clear with that. I was very adamant about him not losing his job or his position. I myself work from home here. I work 10 hours a day. And
so what do you remember about June 1st? Tell me about June 1st.
I was in the house and the kids were outside playing. And there's some prehistory to what happened with Gabe. Gabe is known, I know he has special needs. My grandson has special needs too. I have a son that's schizophrenic, so I'm very familiar. I would never insult anybody, or especially a child, about having these kind of issues. But Gabe, he's aggressive, as on top of things. He's calling the kids.
So what happened? Tell me what happened from your point of view. Let's get there.
This is why I'm trying to tell you what happened, because I've talked to Gabe before, a couple times, about not talking to the kids, or cursing, or throwing rocks, or sticks, or dirt.
So do you have kids involved in this?
I'm raising, and one of them's here to testify, because she was standing right there. She's 12.
I'm going to hear from you. So,
I was in my house.
You have a child that interacts with Ms. Hull's child.
Occasionally, yeah. I kind of tried to limit.
So tell me what happened. What I'm being told is that, you read the petition.
Yes. Okay.
I'm being told that you yelled at Gabe and then he came home crying. So what happened?
I was in my apartment. The children came in and told me that Gabe was saying the P word, threatened to kill some of the kids.
What word?
I'm sorry. The P word. And he was saying all kinds of words again. I'm sorry I had to say that. I'm embarrassed.
So stop interrupting. I know this is tough, Ms. Hull, but you're on record. You're interrupting my record. So keep your comments to yourself. I know this is difficult for both of you. It's always difficult when people are talking about these situations. It's emotional. So just keep it inside. And don't make comments, roll your eyes, do anything like that. All right. So I'm hearing from Ms. Burden. So Ms. Burden, go ahead.
Okay, so the kids came in. They told me that Gabe was doing things again, saying words, cursing. They said his mother had come down previously to tell him not to curse, so she was aware he was doing it. After she left, I didn't see that.
Did you see any of this, or you just heard this from the kids?
Yeah, and she'll tell you.
Okay, all right. So next.
And so I told him, don't play with Gabe anymore. That's it. And Gabe was walking, actually he was running by chasing a kid named Kingston, and I was standing at the door and I said, Gabe. And he stopped. I said, my voice was firm. I was not yelling, but I said, Gabe, that's it. You promised me twice. You pinky promised me. He gave me a high five another time, promising me you would not be cursing, or because he was chasing Kingston, saying, I'm going to murder you to Kingston. Kingston's only 4. And I said, that's it. You're not allowed to play with kids anymore. And I was firm. I was not yelling, but I was firm. I said, that's it. You're not playing with Jalen and Layla. They're too old to play with them anyways. They're 15 and 12. He's 9 years old. And so I said, that's it. So he looked at me and he burst into tears and he ran off. So I was like, okay. And I told the kids, if he comes and plays and stuff, just don't engage with him. You can't play with him. He's too young and he's not, he keeps doing this. Just don't play with him. And so I went back in my apartment. It was, Sunday, I was enjoying myself, and I heard this. It wasn't a knock on my door. It was a bang, 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 bang. She was set at 80 already when she hit the door. So I can understand that something happened, it's a kid's involvement. I opened the door. She started screaming at me. She was yelling, "Don't you yell at my son like that ever again if you want to." And I didn't even let her finish. I just shut the door because I was not going to engage with that. I shut the door. And so I just stayed in there for a few minutes and I was thinking, I'm just going to.
Did you say anything at that point?
No, not at that time. No, not at that time.
All right, so you shut the door and then what?
Sorry, there's weed whacker right outside the window. So I shut the door and I waited a few minutes and I'm like, okay, I need to just bring the kids in, which I've done a lot and it's not fair, but I do that. I don't let them out there playing if something's happening. So I went to go out to get the kids in and they're over here playing basketball and they're my grandchildren. I'm raising my grandchildren, 3 grandkids. So I've had them since they were babies. So I start to call them in. And then her neighbor comes, and I don't know her. Her neighbor and her neighbor's husband comes. And
So what was your next contact with Ms. Hull?
I'm telling you, I'll get into that.
With Ms. Hull, not with her neighbor, not with her husband, but with
I'm
Ms.
just
Hull.
telling you the reason why I was outside. I wasn't in my house.
I know. Tell me when your next contact with Ms. Hull was.
Then, right after
Ms.
that.
Hull?
Right.
Okay.
She came down
and what
here.
happened there?
She came. She came up to, and she was standing on the sidewalk by the apartment, and she starts yelling at me. She says, "Don't you know my kid is?" She said what she said in here, and I said, "Yeah." I said, "My kid has special needs too." I didn't make fun of him. What kind of person would I be to do? I would not do that. And so she starts yelling. Well, you need. I said, "Listen, I'm not talking to you." I kept telling her, "I'm not talking to you. I'm not going to talk to you. Please go home or go away. Is your husband available to talk to? Because he's much more reasonable." This is what I kept telling her. And she just kept yelling. And the kids will tell you, she kept yelling. I'm like, "I'm not engaging with you. I'm not talking to you." And I think that made her angrier. And I did tell her, I said, "Can you go please put a bra on?" Because she wasn't wearing a bra. There's a reason for that, why I said it. Hello.
Right.
And see,
So you agree with those information. And then what happened?
She calls me all kinds of names. She calls me a fat ass. She calls me a horrible woman and a horrible person. And everybody talks about me, blah, blah, blah. And that she'll kick my ass if I ever talk to her kid like that again. She said it. And just because I'm a bigger girl doesn't mean that I'm a bully and that I fight. I've never been in a physical fight in my life, ever. And I've never threatened anybody. I called the police because she threatened to hurt me. That's why. And she was cursing and calling me names. I've never spoken to this woman before. I didn't go to her house. She came down to me. She had some gall to put a harassment order. Because
so it all occurred just on that Sunday. Everything kind of came to light on that Sunday.
This incident happened that day. So since then, I was coming home on the 7th. On this order says I can only go in and out of my apartment, and I'm supposed to stay 50 feet from the thing. But we have a common area laundry room. We have a mailbox. We have a clubhouse. We have late access. I have not been able to go out there. I've been sticking to this order for 2 weeks. And when I was out there on the 7th, she's standing up by her apartment, staring down at me, up above and looking down when my mom was here. My mother's here too. She can say that. Like, why is she staring? And I can't see very well because I didn't have my glasses on. I said, "Is that her?" And the kids are all like, "Yeah." And I'm like, "Why is she out there staring at me?" Because I was outside my apartment. It was very weird. If anybody's getting harassed, it's me. She came to my house and I didn't curse her. I didn't say anything to her. I didn't tell her. I told her.
Yeah, our hearing here is about the petition that was filed. So, all right. So this all kind of occurs on Sunday.
Yeah.
And not good on both sides, it sounds like. All right. And anything else, Ms. Burton?
Can I make some statements about things that were put into their statement?
Yeah, you should. That's what this is all about.
Well, I want to address some things. I've addressed the things that she said. That those are lies. That's not how it went. It went. I was not wanting to talk to her husband to get him fired or talk to Leanna to get him fired. That was not my intention. So there's no use of like intimidation. I called the police because she told me she was going to hurt me. She wanted to kick my ass and she was using curse words and yelling at me. I didn't say anything of that nature to her. And then we go on to Richard's statements. I thought he was reasonable. Him and I have had many conversations about our children and my children, my schizophrenic son. He also knows why the police were at my house because my grandson was still running away last year. He stopped, thank God. So I was working with the school and the school resource officer, Mr. Rose, Officer Rose, to find him. So I'd call the police and the cops would come and check and then they go look for him. I've never had the cops called on me. I've never been in jail. The last ticket I had
So
was
you
like,
said you were gonna refer to the statements
that's
in
what
the
he
petition.
said.
Let's stay focused. All
Well,
right.
he's saying that. He's saying that people complained about me yelling at the kids. I have yelled at the kids before. I'll give you one incident. There was a 5-foot pile of dirt in front of my window, right in the parking area in front of my window.
So
and the
I'm more
kids were-
concerned not with the kids. I'm concerned
Okay.
about unlawful harassment potentially committed against Ms. Hull, and that's what
No,
the
I've never
allegation.
spoken to her before, and I've never spoken to her before. I've spoken to Richard. We had a nice thing, but he's not on the petition. I have spoken to her son quite often. He's out there, with other kids playing. When I send popsicles and cokes out to my kids, I give them to the other kids. I'm not a mean lady sitting on the lawn saying, get off the lawn, screaming at the kids, drinking wine or beer on a chair in front of the thing. I barely even go outside. That's what's so amazing because I work indoors. I have to be here. I work for the Department of Health. I'm on the computer all day. So I'm just kind of shocked about the whole thing. I feel like this is a waste of everybody's time. I don't think it's necessary for harassment order because I don't deal with them. I've made a decision. I told her just, and I've told the landlady, and she agrees. There's been incident with Gabe and other kids with Gabe and all kinds of stuff going on. My kids are too old to play with them. I want to enjoy my apartment. They enjoy their apartment. And we just don't speak to each other. And that's the way it should be. Don't come to my house, knock on the door, threatening to kick my butt anymore. Or call me a fat ass. Leave me alone. That's it. And the kids won't play with Gabe anymore. That's just the way it is. And it's sad, but he's too young. They're
Right.
older. I need to not play with them.
Well, let me kind of review something here real quick before I see if I have any further questions of you, Ms. Burden.
You can talk to my granddaughter too, Layla Devine. She's here. If you need to.
So, all right. So Ms. Hull, Ms. Burden, I'm ruling here. It's not an argument. I'm not issuing any further order. What I have to find under the law is not what's occurred here. It's uncomfortable. It's ugly. Obviously, it's one event here. It went on a little bit. I have to find a knowing course of conduct. I have to find that Ms. Burden has knowingly and willfully engaged in a course of conduct directed specifically at Mary Hull with the intent to create substantial emotional distress. I don't find that. I find a misinterpretation. Maybe she yelled, maybe she firmly corrected. Both of you are credible. Sounds like you need to just stay away from each other's. The kids, you all are in control of your children. You decide who they have contact with or not. There just isn't anything defined under the law as unlawful harassment. It's uncomfortable and a bad situation and maybe an obnoxious neighbor, but that's not a basis for issuing the order pursuant to the law. So there will not be any order after today. I leave it to the two of you to deal with your living situation and your children as you will. Ms. Hall, you have a question?
I do. So do I have any legal recourse if she continues to say because under oath, I in no way physically threatened her. Do I have any recourse against her saying if she continues to cause trouble and say, I wouldn't threaten somebody physically. I'm not even physically.
So I'm
able.
not here to dispense legal advice. What I can tell you is I don't find unlawful harassment on your petition committed by Ms. Burden against you. And that's the finding. So that's why the order isn't in existence. Sounds like the two of you don't want anything to do with each other and don't want your kids to have anything to do with each other. So that's up to the two of you. And I'm going to give you a copy of this order if you'd like. The denial of your request is the law just doesn't allow me to issue this order. So Ms. Burden, that order will be in the court file. You can access it. The order is no longer in effect.
Okay, thank you, Your Honor. Thank you.
You can be on your way.
Thank you.
Table there. Mark Neal, are you out there in Zoom? Mark Neal.
I am here.
People make this waiver in avoidance of all doubt.
Ron appearing on behalf of the defender's office. She's
got it. She's got it.
Anna Mack on behalf of.
Just do whatever.
Anna Mack requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
Permission to practice is granted. I appreciate you're just taking charge. Go ahead.
Your Honor, we waive any conflict between this honorable court and our office. If any conflict were to arise, we waive that conflict so this honorable court can hear these matters. Thank you.
Court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided they're under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case. People of the state of Michigan versus Imbaye, is it India?
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good morning.
Good morning, Your Honor. Assistant Public Defender Qasim Bobes on behalf of Mr. Mbaye Ndaye. Is he here? I have not spoken with him, Your Honor. Mr. Ndaye? Your Honor, I have not had any meaningful contact with him, unfortunately. Was going to be asking for an adjournment. There is an offer. He did pay about $3,000 to get out. There was an agreement between the Attorney General's office and I, but have not been able to reach him.
He's not here. How much is currently owing on the child support council?
So, Judge, my understanding is that the defendant posted the bond. It has not yet showed up in the child support system, but his current arrearage, Your Honor, is $20,287.86. I'm wondering.
You said 20. I'm sorry. You said 20,000.
$20,287.86.
Thank you.
Judge, I know you have a mechanism to have those bonds. Do we know whether they're processing that bond over to the child support case?
They should. Yes, our mechanism is that the order would read to pay that bond over. And I think that has, I just want to make sure that the bond form indicates that. And it does, to send over to circuit court. So he's paid about 3,000, a little over 3,000 of that amount.
That's correct.
So it's about 17,200 that's still owed.
That
so
would be
bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $17,200. That's cash to be paid to the circuit court if posted. That warrant will issue immediately.
Thank you, Your Honor.
And Your Honor, will that be an immediate bench warrant? And do you need the AG to prepare and submit it, or will the court handle that?
No, we will handle it, and it's an immediate bench warrant.
Very well. Thank you very much, Your Honor.
All right, thank you. Court does call the case of People versus Devontae Davis.
Morning, Your Honor. Alex Warren, Green on behalf of Mr. Davis. Mr. Davis, can you state your name for the court?
Devontae Davis.
All right, thank you.
Your Honor, at this time, we are asking the court to set this matter for preliminary examination.
And all discovery is complete.
Believe so, Your Honor.
And which one are we on, July? Really? 12 years out?
Oh, I'm sorry. It's a
Oh,
week from July 1st.
I thought so. People have their witnesses available July 1st. Preliminary examination in person will be set July 1st, 2025. 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Alan Ballou.
Good morning, Judge Lawrence H. Margolis with and on behalf of Alan Ballou. Alan, please state your name.
Alan David Ballou.
Judge, this is a referral, we hope, to the Veterans Court. He has been accepted into the court, and we are prepared to go forward with a plea today. If Your Honor will take it, he has been advised of his rights. He has signed a waiver. He is also prepared.
What is he pleading to?
Disorderly.
Your Honor, I don't know if Douglason people, Your Honor, I don't know if Your Honor had a chance to sign the referral and if that paperwork.
I have the referral that I will sign off on, but I don't have a plea form. I don't have anything.
Then we aren't ready for the plea, because we needed you to sign it, so that's what we needed.
Yeah, that was the one thing I was waiting on, was hoping we could do it this morning, but I don't obviously mind
Do
passing.
what this morning?
Sign the plea form. That was the only thing that was not prepared.
I don't kind of need that.
I was hopeful that Ms. Douglas could.
Okay, what am I doing? Because otherwise I'm just gonna do what I'm gonna do.
I have an email at 9 a.m. with maybe the information that you're looking for. I don't know.
At 9 o'clock this morning?
Yes, I have not reviewed it. So Your Honor, he was trying to get him referred to Veterans Court. I had not received confirmation that he'd been accepted, and that's why I didn't do the plea form, because he needed paperwork.
No, I got you, because I just signed off on the referral. So I can't really do anything.
And I apologize, Your Honor, I was under the assumption that the emails that I had provided from Mr. Graveline stating that he had been accepted into the court and that this was going to be pled today was going to be sufficient, but
Probable cause in this matter will be adjourned June 26, 2025, 9 a.m. Bond will continue. You guys get your stuff together and then I'll deal with it.
Thank you, Judge.
Court does call the case, People versus Larry Hickman.
Judge Kennedy, after people, Your Honor.
This was the.
Yes.
Good morning, Your Honor. Student attorney requesting Andra Savvy requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinruli, representing Mr. Hickman, who is present in person today.
Permission to practice is granted.
Thank you, Your Honor.
I
Your
guess
Honor,
the first thing we need to take care of is there were additional counts added, counts 3 and 4. I think we got the counts straight. Have you reviewed those with your client?
I believe Ms. Ikiri Akinruli has reviewed those counts with Mr. Hickman. No. The new counts were they reviewed with you yesterday? No. No?
Where is Miss Akinruli then?
I'm not sure, Your Honor. I believe she may be in another courtroom at this time.
Well, has anybody gone through the other counts with him that were authorized? Or you don't know? I'll take that as that I don't know, huh?
Yeah, I apologize, Your Honor. I cannot provide an answer to
You
that at
take
this
it
time.
back, I'll pass the matter, we'll have to bring him out later. I have to go through those other counts. Court does call the case of the people versus Brandon Clemens.
Good morning, Your Honor. Attorney Jonathan Paul for Mr. Clemens.
Clemens, can you state your name, please?
Yes, sir, Brandon Clemens.
And that's okay. My God. Okay, thank you. All right.
I wasn't sure you were going to do it.
That's the one report that I got
Yes.
last minute. All right. I have before me a plea form that indicates that the defendant is going to be pleading guilt. Well, is he going to be pleading guilty or no contest? Because otherwise I've wasted my time reviewing a plea.
Your Honor, he's pleading guilty.
Pleading guilty to the charge of operating while intoxicated with an occupant less than 16, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
Yes, sir, that's correct.
Yes, Your Honor.
Mr. Clemens, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes, Your Honor.
State your name again for the record.
Brandon Clemens.
Put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated with an occupant less than 16. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor. Yes, Your Honor.
All right. And understanding all of that, well, and I'll also indicate to you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before a judge. Need a name? Before Judge Perry in the 15th District Court. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, sir.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor. Yes, Your Honor.
You understand you're giving up your right to appeal of
yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Pardon?
I currently have a sober breathalyzer.
You're not
right. Are you under the jurisdiction of any other court, sir?
No, Your Honor.
All right. Have you ever been to prison for longer than a year?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor. No.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor. Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
All right. And you understand that if you commit any type of misconduct between the time of this plea and the time of sentencing, that you would not be entitled to withdraw your plea unless allowed by the court for a good cause. You understand that?
Yes, Your Honor.
You also understand, sir, that if you do commit misconduct during that time, the sentencing judge would not be bound by any recommendation or evaluation.
Yes, Your Honor.
Is counsel aware of any other pleas, inducements, or threats that have led to this plea?
No, Your Honor.
Counsel, I didn't hear you.
No, Your Honor.
All right. Sir, on the date of April 3rd, 2024, at the location of Liberty Street near Maple Road in the city of Ann Arbor, Washington County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I had drank heavily the night before, and then the day of that morning, I had about 2 twisted teas. I think my blood alcohol was mostly from the night before of me drinking heavily.
Were you stopped by the police or was there an accident?
I was stopped by the police. There was
Why did they stop you?
I did bump a little bucket inside of the store, but they stopped me because of the driving that they had witnessed.
Are you disputing the right of the police to stop you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
And were you taken to the station or the hospital?
I was taken to the station, Your Honor.
Was there a data master or breathalyzer test of some type?
Not on my end, Your Honor. They took me to the police station, and then later they took me to
Counsel, was there a breath test or a blood test in this case?
Your Honor, it was a blood test of
I have the
0.248.
labs.
Did you take a blood test, sir?
Yes, Your Honor.
What were the results of that blood test?
0.248, Your Honor.
0.248? Sir, do you have any reason to dispute those blood test results?
No, Your Honor.
Was there an occupant in that vehicle
You broke up, Your
besides
Honor.
you?
Yes,
Pardon?
there was another occupant in the car, Your Honor.
Who was that?
That was my girlfriend's son.
And how old is he?
He is currently 6.
At the time, how old was he?
He would have been 5 years old, Your Honor.
Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea. 2 count 1 is dismissed. The precinct investigation and screening assessment is ordered at 15th District Court. Sentencing in this matter will be July 14th, 2025, 8:30 before Judge Perry.
Thank you very much, Your Honor.
Bond with its conditions will continue. Thank you.
You can sign off, Brandon.
Thanks.
Court calls the case of the people versus Michael Patterson.
Can I be asked to be there?
I have 2 cases. Second, really? Hang on a second.
Good morning, Your Honor.
Pardon?
I said, good morning, Your Honor.
Not really, but thanks. Good morning to you.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Patterson. Today is the date and time set for the probable cause conference, Your Honor?
Yes, in both matters.
Set up a preliminary examination.
What's that?
Set up a preliminary examination covers the all.
Oh, that's from the prosecutor?
Yes.
The hospital. So today, I would like to be concluded from this situation, in this case, just to be further admitted into the psychiatric hospital. He already ordained that.
We'll do that as part of the bond.
All
Your Honor, today, there are no offers from the prosecution. My client will respectfully request that this matter be set for preliminary examination. We'd also like to address the bond at the appropriate time.
You want preliminary examination in both cases, sir?
Yes, please.
To your knowledge, I'll discover his complaint.
To my knowledge, yes.
People have their witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor. As to bond, we're asking for a modification. My client indicates that he has already been determined to be released to, what was it?
I'm sorry?
To Havenwick, Arbor Hills, Havenwick Hospital for psychiatric treatment.
Arborwick, Haven Hills Hospital, we're asking that his bond in these cases allow him that similar release to, what's the name of it again, please?
To Auburn Hills, Havenwick Hospital.
Auburn Hills, Haven.
For treatment?
Yes, please.
And you say he has that in his other cases, or?
Yes, the last time I was here, that's what I was before you, Judge Simpson, and
Yeah.
you ordered for me to go there.
I think I ordered release to inpatient treatment.
That's right. That's what I want.
But I think did we already order it?
Well, it sounds to me like.
Yeah, on my last court date, that's what was that was ordered by you personally.
Okay, I don't have an order. If it's a release to inpatient treatment, I am not going to have an objection whatsoever. So where's Ms. Yagi? Ms. Yagi has an order that she has prepared that probably all of the public defenders should use, that I'd be more than happy to sign off on, that I've signed off on for the last 5 to 10 times for her.
I know Ms. Yagi will happily share.
Thank you, Ms. Yagi.
Because we are one happy family.
I don't know about all that. All right, so at this point, what I'll do is his bond will continue. And once I receive that order, I'll sign off on it.
Thank you very much.
All right, thank you.
Thank you, brother.
You're welcome.
Okay, to whip him into shape. Court calls the case, People versus Mary Collins.
Andrew Bannon for the people. Good morning, Judge Coverell, on behalf of Mary Collins, who is approaching the podium. And Ms. Collins, please introduce yourself to the court.
I'm Mary Collins.
Thank you.
And Your Honor, today's the date and time set for probable cause conference. I have spoken to Prosecutor Bannis. We are working on a resolution. I do have a adjournment form for the court's file.
Probable cause conference in this matter will be adjourned to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, Judge.
Court does call the case, People versus Lakita Roberts.
Andrew Bannon.
Have you start working.
Hannah Mackey on behalf of Ms. Lakita, who's approaching to my right. Please state your name for the
Lakita
record.
Roberts.
Your Honor, we're respectfully requesting an adjournment. We believe that we could discuss a possible global resolution in her circuit court matter as well.
So she has things in circuit court.
She does, Your Honor.
And when's her next date in circuit?
Don't know that one.
You're gonna do a global resolution, don't you think you should know that? I'll wait.
Your Honor. I see a case, according to X jail, a circuit case scheduled for 6/25, June 25th.
June 25th, Your Honor, is the date.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond continue.
Thank you.
Court calls case of the People versus Bianca Rao.
However, on behalf of Ms. Rowell, who's approaching the podium. Ms. Rowell, please say your name for the record.
Bianca Rao.
So, thank you, Your Honor. So we are, today is the date and time for probable cause conference. We have worked out a resolution. I've provided documents to the prosecutor, Mr. Bannis, today, and I have a few more that I'm going to email that Ms. Rowell provided for me today. We just need to have first APA, Burton Harris, look at these documents. So we are asking for a brief adjournment, hopefully the last.
Probable cause conference will be adjourned July 3rd, 2025.
Thank you, Judge.
Any bond continued. Court calls case People versus Thomas Vasher.
Andrew
Not present.
And Alex Warren Green on behalf of Mr. Vasher. Mr. Vasher, can you state your name for the court?
Thomas Vasher. Are we gonna get breakout room or something?
Oh, Your Honor, I went to the jail last night and
Yes, you did. He wasn't there. He's in the hospital.
he has been transported to the hospital.
Yes.
So I'm asking for an adjournment. The people generously did extend an offer. I want to discuss that with Mr. Vasher. And if I may ask on the record, Mr.
Now-
Vasher, do you anticipate when you'll be discharged and returned to the jail?
No, actually, they just talked to me and I plan on staying here. They need to run
Okay, well,
different tests.
Mr.
and see what
Vasher, call the
legs are-
public defender's office if you can. And Your
Well,
Honor,
how
I'm
come
respectfully asking
breakout room and
for
you
an
can-
adjournment.
Or can you address my bond at least? Because I'm here on my bond's been violated because you guys.
Mr. Vasher,
While I was out.
Your Honor, I'm requesting an adjournment to the next available
well,
date so I can talk
to
to
address
him.
my bond. I'm asking you that.
I'll give him an early date. That way you can go talk to him and see exactly what it is his complaint is. June 26, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
I want a new counsel.
Court calls case People versus Julius Holston. That's on.
Good morning, Your Honor. Edward Rodriguez on behalf of Julius Holston.
Good morning, Julius Host.
Your Honor, there was a resolution that was worked out this morning. It would be a no contest plea. I have a plea form if the court's able to allow that. Otherwise, we'd be asking for an adjournment.
No contest. I haven't even read a report.
I understand.
They're supposed to get to me at least 24 hours. I don't mind doing the work, but I'm not going to do it on this day. So I'm going to put it over and then I'll take your plea.
Okay.
But I'm not going to do it. I'm not going to do that today.
That sounds like a plan.
Probable cause conference, June 26, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Demarius Tubbs.
Andrew Bennett.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051 on behalf of Demarius Tubbs. Mr. Tubbs, please state your full name for the record.
Demarius Tubbs. All right, first order of business is I need a substitution of attorney filed. Mr. Martell, I'll let you go ahead. I realize you filed an appearance, but I think you know the court rules require a substitution of attorney.
Yes, Judge.
All right, what are we doing today on this?
Judge, it was my expectation that charges would be filed federally by now. I have not received any. So, Judge, discovery is complete. I'm asking for an examination date. Please and thank you.
I didn't hear any of that. You need a better microphone.
Forgive me, Judge. Discovery is complete. We're asking for a preliminary examination date.
People have their witnesses available July 1st.
We will do our best, Your Honor.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Always a pleasure. Have a great day.
Court calls case People versus James Chandler.
Alexander on behalf of the people, Your Honor.
And good morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of James Chandler. Mr. Chandler, can you please state your full name for the record? James Chandler.
Where's the rest of his pants?
I was at work. He was at work, Your Honor.
Really?
And that's and one thing about it is my apology. I had told him it was going to be 2 p.m. And once I seen he was on the 9 a.m. docket, I called him later. He hurried up and got up.
And so what, his pants weren't ready or what?
He probably didn't have any pants where he was.
I see. Oh. Okay,
But now that,
it won't happen again, right?
never again.
Yeah, okay, go ahead.
Okay, today we're
Sir,
gonna,
that's not your fault, it's his. Yeah, don't worry about it.
it is,
I got, oh, I know, everybody knows it's your fault.
I take full
All right.
responsibility. Now, we're just asking for a slight adjournment because the prosecutor needs to check to see if the body cam has audio, Your Honor.
That's correct, Your Honor. Media's been provided, but it's my understanding that Mr. Bird's media doesn't have audio, so I need to check in if there is audio on the videos.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Fill out a green form?
I did, Your Honor.
All right, yay.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Philip Brown.
Regardless for the people.
Okay, where's Burgess?
He's here.
Good morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Philip Brown.
All right, what are we doing?
Your Honor, this was a reissue. I have had discoveries for some time, so we're requesting an exam in this matter.
People have witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Barr.
Judge, may I briefly address the issue, Bond?
You may.
Thank you, Your Honor. Your Honor, bond is currently set at $250,000 cash surety in this case. Understand the serious nature of the charges, but the allegations are that the complainants in this case ran up into my client's girlfriend's house where he was staying. The police report is somewhat vague on whether the incident occurred outside or inside the residence, but be that as it may, Your Honor, on my client's actions, we do take the position that my client was acting in self-defense of himself, his girlfriend, and her home. And all three witnesses on the case before didn't appear at the last exam, Your Honor, after speaking respectively to their counsel, which they needed appointed because of their potential Fifth Amendment issues. So based on that situation, Your Honor, I think that the bond should be lowered, maybe 50,000, 10%. My client didn't want me to ask for a PR bond. I know the charges are serious, but I do think under the circumstances, the bond's excessive. Thank you, Judge.
Response.
I believe that the bond is appropriate. The report is not vague about where this took place. The allegation is not that these people ran up in the house, it's that they did go to the house, and that this occurred outside, and that a neighbor who was uninvolved witnessed part of this, and it was the reason she was able to witness it is because it happened outside. And so, Your Honor, there's the allegation that he shot at 3 different people in the front yard. As far as the cases, 2 witnesses that were able to be contacted for the exam when this was initially issued did want to move forward. They were not able to come on that date. And so the people were unable to get an adjournment. And that's why there was a dismissal and immediate reissue. It's not that they didn't want to move forward. So, Your Honor, we do believe that this bond is appropriate.
Who was this case originally before?
Judge Washington? Yes. Judge Washington, I believe, Your Honor.
But no testimony was heard?
Correct, Your Honor. We've adjourned it a few times for them to
Then
speak to counsel.
I'll leave it before. All right. Anything else?
Your Honor, only that the 3 people that came to the house came uninvited, and they were all, this was over a dispute, so they were coming there, obviously.
Were they armed?
Yes, Your Honor.
Your Honor, there was one individual who admitted he had a firearm. However, he is not accused of trying to shoot him.
Only accused of bringing a gun to a stranger's house without permission.
Yeah.
I believe there was an AR-15, Your Honor. That's a semi-automatic rifle.
But there are 3 felony firearm charges here at the 3 in possession of the allegations that he's a prohibited person, so he shouldn't have a firearm or ammunition. And then I have 1, 2, 3 counts of assault with intent to murder and assault with intent to do great bodily harm less than murder and carrying concealed. All right. Anything else from either side?
Your Honor, there was one minor, there was a no contact issue to his girlfriend, Latrice Hargrove, when he was rearraigned on this case. That had been lifted last time. It was a confusion as to that. She's just his girlfriend, not a complaining witness to the case. I just asked that he be allowed to have contact with her. She'd be a defense witness in this case.
Any response to the no contact?
Your Honor, she is a witness in this case. I believe that the no contact was issued because part of the conflict is supposed to have been based on allegation that Mr. Brown had done something to her daughter, but I believe that discussion.
Okay, I'm not going to change the no contact. I'm going to leave that where it is at this point. I'm also going to deny the defendant's motion for a bond reduction. Bond will continue. Thank you.
So if you need another copy. Okay.
That's called the case of People versus Leorn McEwen.
Yes, Your Honor. Please, this honorable court again, Brandon Bird on behalf of Leorn McEwen. Mr. McEwen, can you please state your full name for the record? Please.
Thank you. All right, what are we doing?
I would really like to get this resolved, Your Honor. But if Sister Prosecutor doesn't believe that we can get this resolved, then we're gonna set this matter for exam.
You have all the discovery.
I do have all the discovery.
People have their witnesses available to first. You need to, sir, you need to hand out.
Oh, I'm sorry.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue.
Just for the record, the offer has been that if Mr. McEwen could provide proof that he could drug treatment, the date of events that would be offered as use, however, that apparently is not.
I say anything? I've been in treatment for 5 years. This case is 5 years old. So is there any way we could adjourn this matter, Your Honor, to provide Sister Prosecutor? I passed all my drug tests, every one of them.
I need a green sheet. Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Thank you. July 3rd.
Okay, sir. Thank you. Thank you, Your Honor. Thank you for your patience today.
Thank
too.
you, sir. What?
Thank you for your patience today.
Oh, no, that's really not in the cards. Thank you. Court does call the case People versus Todd Rayberg. Now you get it. All three
Morning,
cases.
Your Honor, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Rayberg. And Your Honor, I do have some paperwork here. I just had it. Mr. Rayberg, could you state your name for the court? I swear I had it, Your Honor. Here it is. I am requesting a brief adjournment. One of these cases is very new and I didn't have the police report yesterday when I met with Mr. Rayberg. I'm also submitting to the court a proposed release to treatment order if the court would consider signing it.
Any objection to release the treatment from the people?
There's no objection.
I'll sign that order. And then I'll grant the adjournment in this matter. On the 6th, which is going to be the day from where you want the 3rd.
I think probably the 3rd, Your Honor.
Good enough.
Thank you.
So probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will.
Thank you.
Okay. Court does call the case, People versus Adam Barry. This is the one.
Oh, different. No, it's one.
Right, the people put their appearance on the record. Joe Simon, you did, right? Sorry, Joe Simon, on behalf of defendant, Mr. Barry, state your name.
Adam Barry.
All right. You need an adjournment in this case.
Yes, I'm going to supply some mitigation documents to the people in support of a
I
request.
think July 10th was.
I will be back, Your Honor, but you may be seeing too much of me on that particular day.
Oh, I'm seeing too much of you every day.
So either the 10th or the 17th, but I have, sometimes the court gets mad when he sees too much of me.
July 10th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Mohammed Dar.
Say it again. Yeah, actually.
Assistant Public Defender Costinville based on behalf of Mohammed Dar, who is present to my right. Mr. Dar, could you state your full name for the record?
Mohammed Hassan Dar.
Thank you.
Your Honor, today's the end time set for probable cause conference. At this time, there is no offer, so we'll be requesting to set this for a preliminary exam at the soonest available date.
You have all discovery.
To my knowledge, Your Honor.
People have their witnesses available the first.
Do our best, Your Honor.
Preliminary examination in person, July 1st, 2025.
Your Honor, may I just bond when
9
appropriate?
a.m. Yes.
Your Honor, my client is requesting a PR bond. He has two jobs on the outside that he would like to keep. This is in a group home. He supports his mother financially by sending her money. He also has some personal matters that he needs to be taking care of on the outside. I don't believe he's a further danger, Your Honor, if the court is inclined to give him a GPS tether or put in the no contact, no go to orders. He's willing to do whatever the court deems necessary, Your Honor.
Anything.
Strong.
I object to any modification of bond at this time. My understanding, Your Honor, is that the defendant was currently on bond at a case out of the 15th District Court, failed to appear at that case while he was hospitalized, which is where this offense took place. In this present matter, the defendant assaulted a nurse by grabbing the right breast, and she was placing a blanket on him. I object to the modification.
Well, we certainly understand how serious the allegations are, Your Honor. As I said, my client is open to any no go to, no contact orders, anything the court deems appropriate. We don't believe that he's a further ongoing danger to the community nor a flight risk, Your Honor, at this time.
His bond is set at this point at $1,000 cash surety. So I think that's appropriate given the allegations in this case. Motion for bond reduction is denied. Bond will continue.
What was that date, Your Honor, for the
July 1st.
Thank you.
Thank you, Your Honor.
July 1st before Judge Barr.
Thank you, Your Honor.
Did I put that in there? I think I did. Double check it. Yeah. Court does call the case People versus David Witherspoon.
Ready, Your Honor. Andrew Bannister.
Your Honor, Joe Simon, on behalf of Mr. Witherspoon, is making his way to the podium. Mr. Witherspoon, state your name, please.
David Witherspoon?
Your Honor, may counsel approach?
Yes.
Thank you, Your Honor.
Recall it later. Court will pass this matter. Recall it later. Court does call the case of the People versus Mark Hubbard.
Ally Zend on behalf of the people, Your Honor. Anna Mackey on behalf of Mr. Hubbard, who is approaching. Please state your name for the record.
Mark Hubbard.
Your Honor, we're respectfully requesting an adjournment. We just received discovery and have yet to go over it with the client.
Is there anything else holding him or?
I don't believe so, Your Honor. I believe
This is the only thing holding him?
correct.
All right, probable cause conference, June 26, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Thank you.
Court does call the case of the People versus Joel Jones.
Good morning, Anna. David Burgess on behalf of Joel Jones, who does not appear to be here.
He's not here.
No.
Got it. Joel Jones, you were just appointed on this case.
Yes, Your Honor. So I don't have a contact number for her at this time.
And well, the reason I'm asking, I think she's been on bench warrant status.
She was, I think I appeared on Zoom on the 20 case, Your Honor. There's 2 cases, I believe.
Right.
Yeah. And I appeared on Zoom that day and I gave her my information, but I did not receive a call from her.
Bench warrant will issue for defendant's failure to appear in each case. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Think you can get that one? Think you can get this one? Court does call the case, People versus Javante Jackson.
Ally Zend on behalf of the people.
I have anybody that left?
I can't see, I'm so sorry.
They are not. They're coming. Javante Jackson, you have Jackson?
Assistant Public Defender Sandra White on behalf of Javante Jackson.
State your name, sir.
How are you doing, Javante Jackson?
What are we doing?
Your Honor, we're asking for an adjournment in this matter. Apparently there are some jail calls I was just made aware of that we need to review.
Your Honor, I'd like to address that.
All right. I'm gonna need a green sheet. All right, yes, Escobar.
Thank you, Your Honor. It's come to my attention, this defense has made 16 complete calls to the victim in this case, as well as 142 attempts to call her. These calls are extremely concerning. Of the call, the victim tells him she wants him to stop contacting her, that she's going to come to court. He continues to keep calling her, as well as having a third party reach out to her. He says to the third party, "You want to do me a solid?" Third party says, "What's that?" He says, "Pull up on that bitch. She's going to cry to you. She's going to do all this crime shit to you. Just pull up on her for me and be like, yo, don't cook." Because yesterday I talked to her and she kept going on about testifying. So I have extreme concerns that he's not only reaching out to the victim, but also third parties to contact the victim on his behalf. And would ask his phone privileges be revoked.
Any response to that?
Yes, Your Honor, I would ask, first of all, we need to review these calls, but that the phone privileges only be revoked to that certain number. Mr. Jackson needs to call his parole officer, so we are asking for the calls to only be revoked to that certain number.
You need to do what?
Calls, have phone calls with his parole officer. We are trying to arrange certain things.
But the calls that the people are talking about aren't parole calls to his parole officer.
That is correct, Your Honor.
Probable cause conference will be adjourned to July 3rd, 2025, 9 a.m. At this time, pending a hearing or request for a hearing, defendants' phone privileges are hereby ordered revoked.
Thank you, Your Honor.
Bond will continue. That was for you. Courthouse case, People versus Joseph Bailey.
Ally Zend on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Bailey. Could you state your name, Mr. Bailey?
Joseph Bailey.
You forgot his pants too?
Oh, Mr. Bailey, you gotta wear long pants in court moving forward. Your Honor,
Pardon me about that.
Pardon?
Said pardon me about that.
Okay.
we're asking the court to set this matter for preliminary examination. And my client does have a request relative to his bond conditions.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 1st, 2025, 9 a.m. before Judge Perry. Mr. Bond.
Thank you, Your Honor. Mr. Bailey is currently on a hot zone tether. He's asking the court to consider removing that requirement. He is a moving truck driver. He's a soccer coach. And my understanding is that this case involves allegations of electronic communications only. So, Your Honor, I believe the no go to and no contact order are sufficient.
But it's an aggravated stalking that may begin with electronic communication.
Understood, Your Honor. I just wanted to make the request.
Response?
Subject to any bond. This is an aggravated stalking when she violated a I have concerns about the victim and would ask that the tether remain on, given that he already violated a court order to initiate this case.
Well, okay. Motion for bond reduction or bond modification is denied. Bond will continue with its conditions. All right, thank you.
Thank you, Your Honor.
I have some. Court does call the case People versus Chad Jones.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Jones, who's approaching. Mr. Jones, could you state your name for the court?
Chad Jones.
And Your Honor, I did submit, or I did fill out, not submit yet, but a green sheet. Mr. Jones is seeking a global resolution. I am asking for another adjournment. We need some paperwork from some other jurisdictions, but I am asking for a 2-week adjournment for
2 weeks. You'll be able to get everything you think in 2 weeks.
I'm not sure, but I think it makes sense to just ask for 2 weeks at this point.
Any objection?
There's no objection, Your Honor.
Probable cause conference. So, well, I have 10 days out, but you want July 3rd date?
Do you have a preference? Okay, that's fine, Your Honor.
All right. July 3rd, 2025, 9 a.m. Bond will continue. Court calls case of People versus Grace Brenner.
And then on behalf of the people.
Assistant Public Defender Sandra White on behalf of Grace Brenner. Your Honor, I have tried to contact Ms. Brenner. She works through a worker and the phone number, I think with Avalon Housing, I'm not sure. I don't believe she's missed any court dates, so I would ask for an adjournment.
Your Honor, at this time, I wouldn't object to the adjournment. Ms. Brenner normally appears on Zoom and Ms. Apple is normally covering her case, so there may have been a slight with Ms. Apple being out this week.
Really?
I believe so, Your Honor. She has been at every previous court date.
And I thank Ms. Zenda. We did talk about that, and she said we did.
You two?
And
so
we're
you
hoping
two
that-
rigged this whole thing for an adjournment?
Yes, and we're hoping you agree.
And Ally signed on?
Yes, she's nice. Sometimes.
That implies,
Sometimes.
that implies others aren't. Who are you talking about?
We're not going to mention any names.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. without objection. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Paris Lester.
Good morning, Your Honor. Kedma Dadish on behalf of Mr. Lester. Lester, can you please state your name for the record?
Yes, Paris Lester. Okay, so Mr. Deuce, let me explain something about what she did. So she didn't know what a shortstop was the last time we were here.
I have a
I did,
diagram.
hold
for
on,
you.
hold on. I then sent you a baseball diamond. With, yeah, you got it.
I have a diagram for you
Uh-oh.
for a game that you won't understand.
Oh, no. So now she wants to play games with me.
That's what baseball looks like to me.
Wow, I'm sorry.
I appreciate that. It's Yellow's turn.
I don't even know what that is. That's what baseball looks like to her?
Looks like a house.
Okay, so I sent her a baseball diamond with all of the positions listed and their number next to them. She's showing it. The response I get back, I was trying to help her, was she called me a troll. I'm just.
I never said those
no, I'm
words.
just pointing that out what you did.
I never said.
No. You want an adjournment?
Yes,
Yeah,
please.
you may.
There are pending charges that are waiting to be authorized, so we are adjourning.
Additional charges against this defendant?
No, never. Yes, again.
So where are they in, do we know where they are in the system and how?
Your Honor, we have the warrant request, but I have to go through them. There's 3 or 4 of them.
There's 3, okay. And is this then the only thing holding him at this point? No?
No.
All right. Well, what I'll do then is I'll adjourn it out. Let's see where we are. I'll just go 2 weeks out, or basically 2 weeks out to July 3rd, 2025.
And for the record, Your Honor, we are, on his other cases, we are potentially working with CMH.
On
right,
those.
yeah,
Got it.
Thank you.
All right. And at this point, it's bond will continue. All right, thank you. That's. Oh. I don't even know what that name is. That's what she gave me. It's some voodoo stuff. Court goes case people versus Dave Ellington. See, I was trying to help her out. You know what a shortstop is, right? Oh, okay, never mind.
Welcome back, Mr. Allen.
Wow. She said, welcome back. She did? Did she miss you?
Oh, no.
Huh? Why did she say that?
Well, I
There's
just
something
was
there.
acknowledging.
No, something's up. She's.
Your Honor, we are requesting a 2-week adjournment for mitigation purposes.
Any objection from the people? Probable cause July 3rd, 2025, 9 a.m. Bond continue.
July 3rd, 7-3, 9 a.m.
Court does call the case of the people versus Tyler Redmond.
Good morning, Your Honor. Intern Malika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender Lauren Brown.
Oh. Bald head. Permission to practice is granted.
Thank you, Your Honor. Appearing with and on behalf of Tyler Redmond, please state your name for the record.
Tyler Redmond. Thank you, sir. All right, what are we doing?
At this time, we are requesting an adjournment to be assessed for the Drug Circuit Court, which is set for June
The
20.
Drug Circuit Court.
The Drug Treatment Court. Yeah,
Circuit Court. I don't know what that means.
Circuit Drug Court.
Okay, go ahead.
It is set for June 26th, so date after.
So they would be, they have their meeting on the 26th.
Yes.
Okay. Any objection from the people?
No, no.
July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. What's she do? I haven't left to sign. Trying to be fancy. Oh, you got it. Court does call the case people versus Latosha Griffin.
On behalf of Ms. Griffin. Can you say your name for the record?
Latasha Griffin.
Latasha Griffin.
Your Honor, we are going to be setting this for preliminary examination. Please.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available. The first preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond continue.
Thank you.
Court does call the cases of the people versus Leo Stringa.
Andrew Banish for the people.
Hannah Mackey on behalf of Mr. Stringa, who is approaching to my right. Please state your name for the record.
Leo Stringa.
Your Honor, we're respectfully requesting an adjournment to write up a plea offer form.
To do what?
We need to write a plea form.
Is this the only thing holding him? Why is every question I ask her a mystery?
Feel the same way sometimes, Your Honor.
Uh-huh.
Said I feel the
Your
same
Honor,
way
it's
sometimes.
Wow.
It's not the only thing holding him in this county.
Pardon?
He has other holds in other counties.
Other
But in
places.
this
In
county,
this county, this is the only.
Probable cause conference July 3rd, 2025, 9 a.m. Bond continue. Did she give me a green sheet?
Oh.
Do you have a green sheet? Or you're just gonna hold it?
No, I'm gonna fill it out.
Oh, you haven't even filled it out. Okay, so the correct answer to that would have been no.
Green sheet. Technically, I have a green sheet.
This is like riding that bus. Demetrius Griggs.
Alexander on behalf of the people, Your Honor.
Stephanie Can on behalf of Ms. Griggs.
Ms. Griggs, could you please state your name for the record? Demetrius Griggs. And Your Honor, we are just setting this for a preliminary exam.
Discovery complete.
To my knowledge, Your Honor, yes.
We will have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination, July 1st, 2025, 9 a.m. That's before Judge Barr.
7 a.m. before, it's here.
I understand what.
Yes.
Bond
9
will
a.m.
continue.
9.
Thank you.
Thank you.
Court does call the case People versus Larry Hickman recall.
People, Your Honor.
Good morning, Your Honor. Assistant Public Defender Chinazi Kyriakiwili, on behalf of Mr. Larry Hickman. Mr. Hickman, could you state your name for the record, please?
All right.
Your Honor, today is date and time set for a probable cause conference in this matter. The people did send over an amended complaint. I think he would need to be arraigned on the additional
Yes, he needs
charges.
to be arraigned on counts 3 and 4. So you do waive their formal reading.
We do waive formal reading of that, Your Honor. We stand mute asking the court to enter a not guilty plea on Mr. Hickman's behalf.
All right. Defendant having waived formal reading, standing mute to counts 3 and 4. Court will enter a not guilty plea.
Thank you, Your Honor. And in regards to the probable cause conference, we'd like to set this matter for preliminary examination, Judge.
You want this set for the prelim?
Yes, please.
And you're satisfied with discovery, even with the added counts?
Yes, we are, Judge.
All right. People have their witnesses available to first. Preliminary examination will be set July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Thank you, Judge.
Court does call the case of the People versus Arlesia Henderson.
Assistant Public Defender Chinazi Kyriakiwili, Your Honor, on behalf of Ms. Arlesia Henderson. Your Honor, she is not here right now. We have spoken to her. She's
What do you
en
mean,
route.
not right now?
She's just not here right now, Judge.
What's that mean?
She had an appointment this morning. She's pregnant, so she did have an appointment that she could not miss. But she says she's en route.
Oh, I'm supposed to have some sympathy.
No, I don't. That's not what we expect, Your Honor. I'm just giving.
That's not, she doesn't. Really?
If you
Well,
like,
no,
it would
you
be
know
nice.
that. I will let you make your argument.
It's Judge, just
Your client's pregnant, had a medical appointment this morning?
that's correct,
Are you
Your Honor.
sure?
I am. Well, that's what she's told us, Judge.
Oh,
Yes. So we did speak to her.
so you
She's-
want me to issue a bench warrant?
I absolutely not, Judge. I'd ask that you pass this matter and see if I can get an ETA for her.
Why do I have a feeling this is gonna end up where she's on a bus?
I don't have pictures yet, but I can. And Judge, we do have a resolution in this matter too, but.
Specifically restored.
I don't know what that is, but fine. I'll pass it.
Thank you so much, Judge.
Court does call the case People versus Dantes Williams.
Alexander, on behalf of the people.
Good morning, Your Honor. Hannah Mackey on behalf of Mr. William.
Your name, sir?
Dante Williams.
Thank you.
Your Honor, I believe we would like to set this matter for preliminary examination.
All right. Did you wish to argue the bond? Your bond motion was also
Yes,
put
Mr.
over.
Brown will do that, if that's okay.
Pardon? Because I believe at this point his bond stands as revoked. Is that right?
That is correct. Can I pass this matter, Your Honor, please?
Yes, this was set for
A bond, yes. Bond
the
violation.
bond as well as I think a PCC, so, but I'll pass it.
Thank you.
Court does call the case People versus Marcus Jones.
Good morning, Your Honor. Council Moves on behalf of Mr. Marcus Jones in the hallway, Your Honor. Just
I just tapped him just to speak.
Find out why they got their hand up. I don't have no idea. Oh, they just put it down.
We'll say your full name for the record, please.
Marcus Jones.
Thank you. Take your hands out of your pockets, please. All right.
Sir, today is the date and time set for probable cause conference. At this time, we're going to be requesting for about a month adjournment. My client is to be starting treatment on July 1st, and we would like to show court some progress so that we can get an offer for my client.
Starting what treatment?
He's starting outpatient treatment.
Yeah.
We're explain to the judge.
CMH. Because I was off my medication for like a few years
Okay, so you're working through CMH.
for treatment,
Pardon?
for treatment to be compliant with my medication.
Okay. Gotcha. Oh, no, we won't have 24. We don't have 24. We only have the 22nd till. All right. Probable cause conference will be adjourned to July 22nd, 2025, 9 a.m. That's a Tuesday.
Thank you, Your Honor.
Round will continue. Thank you. I got one. Court does call the case People versus Dominic Kelly Payne.
Good morning, Your Honor.
Katma Dadish on behalf of Mr. Kelly Payne, stepping in for attorney of record, APD Alexis Plumai.
Okay. Mr. Payne, state your name, please.
Dominic Kelly Payne.
All right.
Your Honor, I believe Mr. Kelly Payne is supposed to be getting a bed at Spera today, which is the reason for Zoom.
Getting.
A bed at Spera.
Okay. Is that where you are, sir?
No, not currently. I'll be there at 1 o'clock.
So you're requesting an adjournment?
Yes, Your Honor, we're going to be requesting an adjournment. She filled out a green sheet.
Well, I'll adjourn it to July 3rd, 2025, 9 a.m. so we can keep a status on it.
Thank you, Your Honor.
Thank you, Your Honor.
Fine, continue. Thank you. Court calls case People versus Nicole Knox.
Andrew Dennis for People.
Your Honor, Alexis Plumai appearing with and on behalf of Ms. Knox. Ms. Knox, could you state your full name for the record? Your Honor, today is the date and time for a probable cause conference. We have reached an agreement with the people. Ms. Knox is going to be pleading to an OWI second, which is a misdemeanor. I believe the court has that plea form.
I do have a plea form that indicates she's going to be pleading to an added count 2 of operating while intoxicated, second offense, a 1-year offense. Upon a successful guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Yes, that is our understanding as well. And I also have a signed advice of rights and sentencing judge waiver form.
May I have her sworn?
Right hand. You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
State your name.
Nicole Knox.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated second offense.
Yes,
That's your understanding?
yes,
That is a misdemeanor punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
yes,
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
yes,
All right. Understanding all of that, you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes,
Any question regarding any of those rights?
no,
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
probation.
You're on probation. Were you on probation at the time of this offense?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no,
Has anybody threatened you or coerced you?
no,
You're doing this voluntarily
yes,
of your own free will.
yes,
All right, and because you believe that you are indeed guilty,
yes,
I do have to advise you, ma'am, that if you do commit misconduct from the time, if I accept this plea, from the time of this plea up until the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, ma'am?
yes,
You also understand that any sentence, recommendation, or evaluation, in this case, the court would no longer be bound by.
yes. I understand.
All right. All right, on date of February 24th, 2024, at the location of Michigan Avenue near Hamilton Street, the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes,
Prior to operating that motor vehicle, you consumed intoxicating liquor.
yes.
What did you have and how much?
I had one margarita.
Pardon?
I had one margarita.
One margarita?
Yes.
All right, were you stopped by the police or was there an accident?
My no accident. My car had my axle had broke.
Your what?
My axle.
The axle on your vehicle broke?
Yes.
Okay.
So I couldn't move. I was stopped by the.
Yeah, usually you can't move without an axle. Did the police arrive?
Yes.
Were you ultimately arrested?
Yes.
Were you taken to the hospital or were you taken to the police station?
Both.
Was there a blood draw?
Yes.
What were the results of the blood draw?
Your Honor, it was 0.173.
0.173.
Yes, the blood draw.
How big was this margarita?
It wasn't that big.
It wasn't that big? You got to a 173 with one margarita.
I think I had drank it the day before or so.
Do you have any reason to dispute those blood test results?
No.
Had you previously been convicted of operating while intoxicated on or about August 13, 2014 in the Third Circuit Court, and of operating while intoxicated on or about July 6, 2025 in the Third Circuit Court?
Yes.
Counsel, are you aware of any other threats, promises, or inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court ruling? Would it be proper to accept this defendant's plea guilty to this charge?
Yes, people are satisfied. Thank you.
Yes, Your Honor, the defense is also satisfied.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and screening assessment is ordered. Sentencing in this matter will be
July 23rd, 5 at 10 a.m.
July 23rd, 2025, 10 a.m. before Judge Barr. Are you on a tether or Soberlink?
Soberlink. And Your Honor, just to clarify, I apologize that I don't know this. Do you refer to CCOP or Von Schwartz for screening pre-sentencing?
Well, this isn't mine, so you're going to have to ask
Judge Barr.
Judge Barr's court who they go through.
Okay.
Bond with its conditions will continue.
Thank you.
It's like a festival site. It was one? Oh, that ain't right. That's a big old market. Yeah, please. If we could order one for the room. Court calls the case, People versus Quincy Jones, both cases.
Andrew Dennis for the people. We're ready in this matter.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Jones, who appears to my right.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, also on behalf of Mr. Quincy Jones, and 21F10574.
Yes.
Your name?
Quincy Jones.
Counsel approach. Or Mr. Jones, because he hadn't shown up and hadn't been testing. We had already been through this with Mr. Jones before. I released him. He assured me that he would do it. I reinstated his previous conditions. That was on June 5th, and we've not seen him test since. So what I will do, and we had talked about adjourning this matter out, counsel's checking into some other options, I guess, maybe for Mr. Jones. I'll adjourn this out to June 26, 2025, 9 a.m. You might want to eat your Wheaties that day. It's going to be a long one. June 26, 2025, 9 a.m. Defendant's bond at this time is revoked.
Thank you so much, Your Honor.
All right, defendant's remanded. Court does call the case People versus Sheldon Lewis. Those are recalls.
And our Assistant Public Defender Counsel will base on behalf of Mr. Lewis.
Andrew Van for the people.
Your Honor, I just did receive a message saying that he's on his way, that he's on the bus. He's been,
No, you didn't.
I got it here.
No.
I got it right here.
No,
I've got it right here.
you had the nerve to come up and tell me on a bus.
May I approach, Your Honor?
No. Is that really what you're telling me? Or
That's
did
really-
you talk?
That's really what I'm
Where's-
telling you.
Where's what's your name? You
I wouldn't make this
No.
up. I wouldn't make
wouldn't
this
make it up?
I would not. Not in front of you.
Another judge you might. Okay, I get that. Where's a bus from where?
Your Honor, I know he's in Ypsilanti. He's on his way here. I
Where's
just received another.
Did Mackie tell you to say that? She be. You don't know where he's come?
I know he'll be here soon, Your Honor. If we could just briefly pass the matter.
You know he'll be here soon?
Yes, I do.
You have no idea if he.
I received assurance from his daughter that he's on his way here just a moment ago.
From where?
From Ypsilanti. She said he left about an hour ago. So I assume he'd be here very soon.
Just take a bus that long? I don't know. Ask Mackie. Mackie, does it take a bus that long?
Yeah.
It does?
I took a bus.
No, you didn't. No, I don't know. I don't even know why you're saying that.
I don't normally ask this of you, Your Honor. Just
No, you would. You absolutely would. I'll pass it.
Thank you, Your Honor.
If he doesn't show up, I'm putting you on a bus.
Fair enough.
Been a day. Court calls the case People versus Derek Martin.
Stephanie, Stephanie Cannon on behalf of Martin.
Really?
Oh, I didn't even look, Your Honor.
Oh.
Your Honor, my client is expressing his sincere.
Do they not make them as they go under the ground anymore?
From here on out, but the shoes are nice.
What?
Your Honor, we're just
You
requesting.
like the shoes?
I like
Hey,
them.
Cannon.
I
No,
like
I don't want to hear about it.
No, we are requesting a 2-week adjournment. My client is of the understanding and knowledge that from here on out, he will dress in appropriate court attire.
Without a doubt.
Probable cause conference, July 3rd, 2025, 9 a.m. Bond continued. Court calls case People versus Kevin McCullough.
We're ready in this matter. Owen Brown, Deputy Chief Public Defender, appearing on behalf of Mr. McCullough. Your Honor, we received a communication from Mr. McCullough this morning.
He's on a bus coming down.
Not in a bus, Your Honor. He is at the Trinity Health the hospital. He does not have a release date. I was able to share the information sent with the prosecutor, Mr. Kennedy. We're asking for a 2-week adjournment in this case.
That, Your Honor, it may explain why he didn't appear at community corrections, given that I believe he's checked in.
How long's he been there?
6:15. I believe is what you showed me.
Yeah, 6:15 is the date.
Well, if he's been there since 6:15, he didn't report to community corrections as previously ordered, and that was before that date. So that wasn't the reason for his failure to go to community corrections.
Well, maybe he was feeling ill before that, Your Honor. You know, us men, we like to procrastinate on going to the hospital.
Okay, so here's what I've done. I'll adjourn it out. But he already has a bench warrant out because of his failure to appear, so I'm gonna leave the bench warrant outstanding. I'll adjourn this. I have the thing for Trinity Health now, but I'll adjourn the probable cause to July 3rd, 2025, 9 a.m. So they'll have to do that, and then maybe I'll lift it.
Thank you, Your Honor.
Thank you, Your Honor.
What is she handing you? This is Mr. Brown on this case. She's handing you another green sheet on what? Something she didn't do before? Like all the way it's already gone, she's just handing it in now? Why? That's an old green. It's like, that case was like hours ago, Mackie. That's all you got. Court calls the case, People versus Joseph Trim.
On behalf of the people.
Hannah Mackey on behalf of Mr. Trim.
Oh, he's in the hallway.
Good morning, Your Honor. Edward Dukes on behalf of Mr. Trim, who is approaching.
Your name? Joseph Trim. Thank you. Really? What?
Your Honor, if we could ask this for a moment, I didn't know I knew he was out of custody, but there's an argument regarding bond that I want to go over with him prior to discussing. I'd be asking for an adjournment, but I do know there's a bond argument as well.
He's out. You want? Okay, fine. I'll pass it.
Okay, thank you, Your Honor.
Court calls the case of People versus Mykesha Melchor.
Gloria Yagi, Assistant Public Defender, written on behalf of Mr. Melchor. Am I saying that right? Ms. Melchor? Yeah. Ms. Melchor, who's standing to my right. Your Honor, I do have a green sheet. I'm very hopeful that we're very close to a resolution. Ms. Melchor, I'm expecting documentation by the end of the day of her intensive outpatient treatment program. So I am asking for a brief.
July 3rd, 2024, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Lanish Mitchell.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Mitchell.
Is that how we have it set?
Yes.
Okay.
What's that?
All right, what are we doing?
Your Honor, upon speaking with Ms. Mitchell, I think it would be necessary for us to adjourn the probable cause conference. We need to do some further investigation based on the information we've received.
All right,
Asking for an adjournment.
I'll need a green sheet. Any objection? July 3rd, 2025, 9 a.m. Bond continued.
And we do want to address one aspect of bond. What's the date? June 19th? And where do you have to be?
Right there. And I'll leave.
Your Honor, my client has a dance team. She is a verified dance mom.
She's what? Dance mom, dance coach.
A dance coach and a dance mom. So her team is going to be, I guess, competing in Minnesota on June 19th. And she'd like permission to be able to travel with her team so that they can, do their thing.
You'll see us on YouTube.
I'm sorry?
You'll see us on YouTube.
You can see us, you guys on YouTube? Yeah, me too. So. Are they any good?
Best.
Yeah, we're the best thing.
Why are you saying, have you seen me around? What? Have you seen them?
It's my client. I did all the way. They gonna win.
Yeah,
So when does she want to go to Minnesota?
well, the event is on the 19th, so
Pardon?
tomorrow morning. We're gonna drive,
Till when?
after the performance is over, and we'll head back
That doesn't tell me. I need a day. Is it gonna be that same day?
21st. It's a 10-hour drive, so it's 10 hours.
Why is everybody explaining all this to me? I understand how far Minnesota is.
Okay, well,
I just need to know, when do
21st
you want to
after, like,
go?
tomorrow morning, yes,
Till?
till the 21st.
And the good news, Your Honor, is she won't be taking the bus.
That was great.
It's on this
Would
floor.
have made it soon.
All right, defendant may travel to Minnesota the 18th through the 21st inclusive for dancing.
You know, we teach
Is it a
everybody.
competition?
It's a performance for the Juneteenth parade, so.
Oh, well, you should have led with that. I mean, fine.
I was
No.
letting him talk.
Oh, you shouldn't do that. All right, yeah, absolutely, you can go now.
Thank you.
All right.
All right, thank you.
Good luck to you.
Thank you.
Troy. Court does call the case versus Keith Moore.
Andrew Banners for the people.
And Alex Warren Green on behalf of Mr. Moore. Your Honor, does the court see Mr. Moore on Zoom? I'm not sure if he. Okay, Your Honor, I talked to Mr. Moore's,
Down the bus with the other guy. Is that what you're gonna tell me?
No, I talked to his community mental health caseworker. She says that Mr. Moore is having some mental health issues right now. I understand CMH has the court's Zoom link, so I wasn't sure if they were going to log in. Your Honor, I'd ask for either an adjournment so that I can, so we can get him to a better place and I can evaluate his competency, or ask the court to pass this matter so he can appear on Zoom. Thank you, Your Honor.
I haven't said anything. I'll pass it.
Thank you, Judge. I appreciate that. I will get in touch with his caseworker right now.
Go on.
Thank you, Your Honor.
It's not cool. Court calls the case People versus Megan Moses.
Anna Mackey on behalf of Ms. Moses, who is appearing via Zoom.
Andrew Banners for the people.
Oh, sorry. Ms. Moses, please state your name.
Hi, I'm Megan Moses. Sorry, I've got a puppy in the background.
Did you?
That's her.
Okay. Your Honor, we're respectfully requesting to adjourn this matter to give Ms. Moses more time to pay restitution off.
The rest, so how much more time is she gonna need to pay it off?
We're still in discussion about how much the restitution actually is.
So we don't even know how much she's supposed to pay?
We do not.
Well, from what
So
I've
when are we
heard,
gonna get that? When are we gonna get that information?
I think there was supposed to be a restitution hearing first before we move forward because there was some issues with what the amount was.
The amount was conveyed, but there was a dispute from the defense or the defendant about the amount. So I would.
And so how's she gonna pay if you guys aren't I mean, what are you guys trying to do? Besides irritate me?
Your Honor, we were given a number at her second hearing, I believe, and then the number increased by a couple $100 somehow at the third hearing. So
I feel like there's more to it than that. What I've heard and what I talked to with a public defender yesterday was the, she was also adding, her therapy costs and her lost wages for going to therapy. So the restitution can't, I was gonna start a payment plan and then the restitution just kept going up and up. So the payment plan wasn't gonna work. And it's just above and beyond what I can even afford without having a steady income or a vehicle or a car, or I'm sorry, or even a steady home at the moment. So that's why we were gonna have the hearing. So it could go back to just the fines and costs and.
What hearing are we having?
Your Honor,
Other than this one, which is going nowhere.
can we adjourn this matter so we can, Ms. Moses?
Yeah.
Can we adjourn this matter so we can discuss with the prosecution what to do moving forward?
Yeah. All right.
July 3rd, 2025, 9 a.m. We can't do anything. You need to set this for a restitution, or not a restitution here, for exam, because I mean, if there's not going to be an agreement on a number for her to pay and then get a deal, we're wasting time.
Thank you, Your Honor. And may I request to address bond, please?
To what?
A bond modification. May I request to address?
Oh, now you want a bond modification. Go ahead.
Your Honor, Ms. Moses was placed on a tether in April, I believe, for a failure to appear to a court hearing when she did not have access to the internet. She has complied with all of her court orders since then. She has shown up to all of her hearings since then. So we asked this court if she could remove the GPS tether. Ms. Moses rides a bike to work and it gets in the way of that as well. It just chafes her leg.
Any response from people?
Yeah, I'll leave that to your discretion. My main concern is that the any or all no contact orders remain.
I'm going to deny the modification at this time, and we can address it on the 3rd, potentially, and then figure out what we're doing.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case, People versus Nicole Nelson. You weren't.
Oh, got the truth.
Good morning, Your Honor. Student Attorney Andrea Sabri on behalf of Mr. Nicola Nelson.
Oh, Andrew Van, excuse me.
Your Honor, Mr. Nelson is not present. I have made multiple attempts to contact him, but I do not have an explanation regarding his absence, unfortunately.
Bench warrant will issue the defendant's failure to appear. Bond in each of these cases will be set in the amount of $10,000 cash surety. Warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Antoine Patterson.
Jacob Kennedy for the people, Your Honor.
Assistant Public Defender Sandra White on behalf of Antoine Patterson. Please state your name.
Antoine Patterson Senior. Thank you.
Yeah, and I've been talking with the prosecution, and I believe Mr. Bellinger has been handling this matter, and we're asking for an adjournment. Just still waiting on CPS records.
Do we have any idea when those might be coming?
No, but we'll look into it.
The green sheet, July 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Taiwan felon.
Phelan? Would you put your name for the record?
Tawana Taylor.
Thank you.
Your Honor, we are going to be setting this for preliminary exam, please.
All discovery is complete.
Yes, Your Honor.
People would have their witnesses available the first. Preliminary examination will be set in person, July 1st, 2025, 9 a.m. That's before Judge Barr. Bond will continue.
Thank you, Your Honor.
Court calls case of the people versus Tyler Pittman.
Andrew Banner.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Pittman. Mr. Pittman, could you say your full name?
Tyler Pittman.
Your Honor, we are requesting an adjournment at this time. We did recently provide the people with a mitigation report, so they will need some time to review that, and hopefully we can negotiate an offer. And I do have that green sheet here.
July 3rd, 2025, 9 a.m.
Your Honor, would it be possible to actually go out one more week?
Why?
Mr. Pittman stated he has trouble getting off work and school on 2 weeks' notice, so if we could go 3.
Is that correct, sir? July 10th will give you enough time then?
Yes, sir.
All right, July 10th, 2025. All right, thank you, sir.
Thank you.
Court calls case people versus Jeremy Schultz.
Assistant Public Defender, on behalf of Mr. Schultz, he's in Wayne County Jail. I'm not sure if, I know it was adjourned previously to writ him out, or at least that's what my notes say. That being said, I was going to request an adjournment anyways, because he just said court yesterday in Wayne County, and so he is going to be held in Wayne County until July 7th, which is his next court date, his sentencing in Wayne.
July 7th.
Correct.
I did send the red email, I think it was.
Oh, that makes sense.
Well, if I set it for the 3rd, he doesn't have court on the 3rd.
Correct.
July 3rd, 2025, 9 a.m. That way it'll be enough time for a writ.
Thank you, Your Honor.
Court calls the case people versus Kirby Snyder.
Andrew Banner.
Stephanie Han on behalf of Ms. Snyder.
Hello, what's your name? Thank you.
And Your Honor, we're going to ask for a, I think I put a 3-week adjournment on there. We're going to have her screened for sobriety court, but we're also looking to negotiate with the prosecutor on this matter.
July 10th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Case of the people versus Matthew Vermillion.
Ellie on behalf of the people, Your Honor.
And Lily Gagne, Assistant Public Defender with and on behalf of Mr. Vermaelen, who's standing to my right. Could you state your name for the court?
Matthew Vermillion.
And Your Honor, we are respectfully requesting an exam date in this matter. I do believe discovery is complete.
People have their witnesses available first. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Cynthia Weber.
And Alex Warren Green on behalf of Ms. Weber. State your name, Ms. Weber.
Cynthia Weber.
Your Honor, today's date and time for probable cause conference, I believe we have reached a resolution. I have a plea form from the people right here.
I don't have it. Give me-
Thank you.
She'd be pleading to operating while intoxicated, second offense.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
All right, ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative program support deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, sorry.
And understanding, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes,
Still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
All right. You signed an advice of rights form, is that correct?
yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
Probation.
Were you on probation at the time of this offense?
Yes,
All right, I do have to advise you that your entry of a plea in this case could be a violation of that probation. You understand that?
yes,
You understand that if it is considered a violation of that probation, that other court could sentence you to the maximum allowable under the other charge. You understand that?
yes,
And understanding that, you still wish to plead guilty?
yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
because you believe that you're indeed guilty of this offense?
yes,
I would also have to advise you, ma'am, that at the time of this plea, if it is accepted in time of sentencing, if you do commit misconduct, then any sentence recommendation or any agreement or evaluation is basically voided and court is not obligated to follow that. You understand that?
yes,
You also understand that if you do commit misconduct, you would also not be entitled to withdraw your plea.
yes.
Hang on. On the date of December 30th, 2024, at the location of Headley near Bartell in Linden Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes,
Prior to operating that motor vehicle, did you consume intoxicating liquor?
yes.
What'd you have and how much?
3 to 4 beers as well as 4, maybe 5 shots.
Were you stopped by the police or was there an accident?
Tree accident.
You ran into a tree?
Yeah,
Did the police arrive?
yes,
Were you taken to the hospital?
yes,
Was there a blood draw?
yes.
And what were the results of that blood draw?
0.112, Your Honor.
Do you have any reason to dispute those blood test results?
No,
Counsel, have there been any other promises, threats, or other inducements which have led to this plea that were not stated on the record?
None from the defense, Your Honor.
No.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
August 4th, 2025 at 9 a.m.
August 4th, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Thank you.
Thank you, Your Honor. I provided the court with a referral to the sobriety court. This plea is in no way contingent on her screening or acceptance, but I'd ask the court to consider signing that. I talked to probation with the sobriety court, and they advised that they could complete a screening between today's date and the sentencing date.
All right.
Thank you, Your Honor.
Court calls case People versus Taylor Adams.
Advantage for the people.
Your name, sir?
Taylor Adams.
All right.
Your Honor, I retained an attorney, but this is now his second. He didn't show up the first time, and now it's the second time that he hasn't showed up. So I'm asking for a public defender, please.
All right. When you say you retained, did you pay him money?
No, his check is here.
Pardon?
His check is here. That's what I was gonna do the first time.
Okay.
Give him the money when he gets here. He lives his office is out of Grand Rapids.
Oh. The public defender case.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Adams. Your Honor, we're requesting an adjournment. I apologize. I received Mr. Adams' contact information. We just need an adjournment to receive discovery, review it with our client. I'll complete a green sheet for the court. I apologize.
Yeah, I'll adjourn this out to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. We'll be in touch.
Okay. Court does call the case People versus Willis Cherry.
Introductions for the people.
David I. Goldstein appearing on behalf of the defendant. State your name, sir.
Willis Cherry.
Your Honor, I'm prepared to ask for a preliminary examination, but I did inquire of Ms. Douglas whether there are any, I do have the written discovery. I don't know if there's any videos. If there aren't, we're ready to go to an exam.
There are videos.
How soon can you get to defense counsel?
I'm showing this as having been discovered, so let me.
Yeah, that would have been to public defender's office.
So I guess it went to the public defender. I can get that done.
Probable cause conference. Are you available the 3rd?
I'm sorry, Your Honor?
Are you available the 3rd?
Yes.
July 3rd, 2025, 9 a.m. Bond continues.
Your Honor, with regard to the issue of the bond, and I'm sorry I didn't get a chance to talk to Ms. Douglas about that. Mr. Cherry is employed, and a lot of his employment is in Lucas County, Ohio, the Toledo area. He is on probation to a district court. They have already given him permission to travel to Ohio, but that's conditional upon you granting that permission also.
Any response from the people? What district court granted him?
15th, Your Honor.
Or is okay with it. I won't.
Really? Okay. I'll indicate that defendant may travel to Ohio for work purposes.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, I will.
My last. Oh. Court does call the case People versus Antoine Pitts. Just that one again.
Yes, Your Honor.
Ms. Douglas, she called Pitts, Antoine Pitts.
Jennifer Douglas for the people.
David I. Goldstein appearing on behalf of the defendant.
He's not
Your Honor-
here.
Your Honor, Mr. Pitts is having some health issues. He has been recently diagnosed with lupus. He has a probation violation in front of Judge Hammoud. The public defender has been presenting to Judge Hammoud notices from the doctor regarding he's been ordered to bed rest and oxygen therapy. I was hoping to have him, I have several of them on my phone. I was hoping for a more recent one. The most recent one I have is from May. But they've indicated he has lupus and has issues with breathing.
Yeah, but we keep letting him out. He doesn't appear. The last time that you were here, I think I told you I was leaving the bench warrant out. I was waiting on medical. I never got any medical to indicate anything.
Okay, I can get those to
And
the
I
court.
left the bench warrant out. And now he goes through the arraignment process, gets released again, supposed to get to community corrections, doesn't go.
Your Honor, I'm assuming he's not going because of his medical problem.
I don't know that.
I was, okay, I'll get that stuff to you, Judge. I've got some of it.
I already issued this bench warrant.
Yes.
He's already got a bench warrant outstanding at this point.
Okay, I'll get the medicals to you as soon as I can, Your Honor.
All right. So I'm just gonna leave the bench warrant out. I'll give a new date on it, but July 3rd. And if he shows up, he shows up. But otherwise, in the interim, there's a bench warrant that's outstanding.
And you'll have the medicals before then, Your Honor.
Recalls the case, People versus David Witherspoon.
Joe Simon on behalf of Mr. Witherspoon, Your Honor.
What's your name again, David? David Witherspoon?
All right. The issue in this case is I did call over. There are no other violations, correct?
That is correct. One you missed.
There was a late test yesterday. Why?
It was 7 minutes. Well, I asked my client and he basically told me he was worried he was going to go to jail today and he was just.
Well, he should be.
Yeah, because I told him to be. And, but anyway, he has he missed the time slot and then just no good explanation other than he just missed. And then he panicked and tested 7 minutes later. But he also wants to let you know he tested this morning too. And there was no violation.
Anything you want to say regarding this bond violation? Because I don't even understand.
He had a bad day and night where he's going to admit drinking alcohol. So that was June 3rd, segue into the morning hours of June 4. And since then, he's been completely compliant other than that 7 minutes. He also wanted to go over to a scram tether because he's so panicked about missing times, etc. He's maintaining that since he'll admit to drinking on the 3rd, but since he's been completely sober also. Regarding the case, we've reached a resolution between the parties, but I just checked with Mr. Heaton, who was here today from the 14A court regarding sobriety court screening. And I know what my client needs to do. If we resolve the matter the way that we principally constructed, I want to get my client screened and accepted into the sobriety court in 14A first. And I think that will only help him in his issues. If in the interim, he can be on a scram. And if all of that is acceptable to the court, I'd request July 17, because it's going to require a few things for him to get done before being accepted.
Mr. Allen, I will adjourn the probable cause to July 17th, 2025, 9 a.m. The defendant having admitted to the violation, I'm going to sentence the defendant 7 days into Washtenaw County Jail. So he'll be released and then can do that upon his release. He's to be placed on a scram tether prior to his release.
Thank you. So, Your Honor, my staff will try to make arrangements with the community corrections in my absence to make sure that he gets that before release, but in the court, as the court knows, sometimes we have trouble with that. Is there any?
But we will prepare an order that needs to be placed on the screen prior to release.
I'm saying for community corrections, the jail always is aware of that, but sometimes community corrections doesn't know to do that. You know what I'm saying?
They're supposed to be contacted, I think, by the jail. That's how that's supposed to happen. But
I've had trouble with that before. We'll do all we can. Thank you very much, Your Honor.
if you have an issue, let us know.
Thank you, Your Honor. That was July 17th. Thank you.
Yes. Court calls the case, recalls the case, people versus Alicia Henderson.
Andrew Banish for the people.
Are we ready on that?
I'm gonna say no.
Court calls case, people versus Dantes Williams. Are we ready on that one?
Yes, Your Honor.
Well, they call for him. Court does, well, that one coming out. Court calls case, people versus Sheldon Lewis. Is that? This is on the bus.
Yeah.
Sheldon Lewis? Oh. Was he driving the bus? Yeah. Well, he wasn't driving it, but.
You're ready on this matter, Your Honor, and here he is.
Here he is what?
He was on the bus and he came.
I know. Did he leave all of his pants on the bus?
Yeah.
We won't have that happen again, will we?
Assistant Public Defender Costin Obasi on behalf of Mr. Sheldon Lewis, who was present to my right. And you state your full name for the record, please.
Yes, Sheldon Lewis.
Your Honor, we're going to be requesting an adjournment for some video discovery that our office has not yet received.
July 3rd, 2025, 9 a.m.
July 3rd.
All right. Oh, that, yes, that's right. Court does call the case, people versus Dantes Williams.
Alexander on behalf of the people, Your Honor.
Brown appearing on behalf of Mr. Williams, Your Honor.
All right, I have before me a plea form in this case that indicates that the defendant is going to be pleading guilty to an added count 4 of aggravated domestic violence to 1 year. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. There was some issue because part of this case had been bound over, but then the case got set back for further testimony regarding an additional charge. I spoke directly with Judge Slay. What she had indicated is that those counts, so after I take this, because those counts exist in circuit court, there would have to be a nollie pros filed with the circuit court to get rid of those cases. I can dismiss them here, at least as a record, but those cases are up. So. All right.
Your Honor.
Yes.
Also, I believe party stipulator agree that he would receive sentencing under section 7694A.
Yes, that is on the plea form.
And that he would agree to no contact with
Or
Ms.
no, not to contest her PPO.
Exactly, Your Honor. Which has already been done.
Having sworn.
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the true self you got. State your name.
Dantes Williams. All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of aggravated domestic violence. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes,
All right. Understanding all of that, you still wish to plead guilty.
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
All right. You have signed an advice of rights form, is that correct?
yes, sir.
Any question regarding any of those rights?
No question, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes,
You understand you're giving up your right to appeal of right.
yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes,
of your own free will
yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes,
Yes.
yes, sir.
I also have to advise you that if there's any misconduct committed by you between the time of the acceptance of this plea and the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, sir?
Understood.
And you also understand that any sentence recommendation and or evaluation, which may include the 7694A assessment, would also not have to be followed by the court. You understand that?
Yes, sir.
Counsel, is counsel aware of any pleas, promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule on would it be proper to accept this defendant's plea?
Do you need a basis? For the
Pardon? Did I not take a factual?
Factual.
You're right. I was so concerned making sure I complied with the new court rule that I haven't. I do have to take a factual basis if it's not in front of me. Thank you, Mr. Brown. On the date of April 2nd, 2024, at the location of 2017 Medford Road in the city of Ann Arbor, Washtenaw County, state of Michigan, what did you do on that date involving a Zaylen Gaynor that makes you think that you're guilty?
We got into altercation and I scratched her.
You what?
I scratched her face.
All right. And who is she to you?
Oh, she was my girlfriend at the time.
All right. You didn't have permission to lay your hands on her in that fashion on that date, did you?
No, sir.
And it was not an accident on your part?
No, sir.
Counsel, have I complied with the court rule now? Would it be proper to accept this defendant's?
Yes, Your Honor.
Yes, Your Honor.
The court will accept the defendant's plea. You count 4. Counts 1, 2, and 3 are dismissed, although 1 and 2, there needs to be the nollie filed circuit court. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 9th, 2025 at 9 a.m.
July 9th, 2025, 9 a.m. before Judge Perry.
Your Honor, may I address bond?
You may.
Your Honor, my client tells me he's been in jail about 9 months. Is that accurate?
I don't know.
Oh, strike that. Strike that. He has not been out 9 months. Now that he's pled to a misdemeanor and the felony charges have been dismissed, I'm asking the court to consider release custody possibly on a tether so he can get back to work. He would stay at 19963 St. Aubin in Detroit, 48233, and have no contact with the complaining witness.
I don't need a response because I'm not going to release him prior. You can take that up with Judge Perry after after he's seen by probation for a screening assessment.
Yes, Your Honor. So bond continues, but once you're seen by probation, call our office. We can take a motion up in front of you. Here's a reminder of your court date and time.
Thank you.
Thank you. Go with the court office.
Court calls the case, People versus.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?